Leave to file this urgent Group 2 appeal with server copy from the list and determination of grateful.
Lordship, with your Lordship's permission, I'm seeking leave to file this appeal, Lordship, with the server copy.
Yes.
Much obliged, Lordship.
Please.
My lord, I am for the appellant. Lordship, by the order of Lordship's order was passed on 7th of July. The
Yes.
Lordship had appointed a special officer
Right.
for operation of the bank account and the object of the Lordship order, the Lordship indicated that the functioning of the partnership firm should not be paralyzed. Now, this is exactly what is still happening. My lord, kindly see the 11th minute, kindly see the first minute of the meeting which was held by before the learned special officer. My lord, here the learned special officer has framed certain SOP. Kindly come to first page, Roman 3, last 2 lines of the first page.
Yes.
On receipt of the permission. So Lordship order is, if I want to incur any expenditure, I have to inform, and the special officer has to, in his wisdom, he has to say yes or no. Now, special officer is saying, on receipt of such permission, I will seek opinion and consent through email from the other side. Now, kindly see your Lordship orders, keep it just on the same side, paragraph 8. 7, paragraph 7 and 8. 8 said both parties to the present litigation shall be at liberty to operate the bank accounts pertaining to the partnership firm with the specific sanction in writing of the special officer each such instance. Now, where there are certain creditors' bill which have long pending even during the tenure when the suit was not even filed, and all the accounts have been all along maintained by the other partner, who is the 50% partner. Now, when we ask him to sanction, the learned special officer says that he will hold meeting, seek opinion and consent from the other side, which will never come, because then the object and purpose of the wisdom of the special officer will not be used, because they will object to every transaction, and this is exactly what is happening now. They are objecting to payment of creditors. Kindly see the last minute, last one on 20th July. Now, what has here happened? The respondent is saying that they need access to the GST and Tally portal. Now, as per the GST and Tally software, both me and he have their separate passwords to log in. Now, he's also aged 70. I am also aged 70. Probably he has lost or misplaced. He cannot access. Here, para 8, we have recorded. We have recorded that we have brought our own laptop before the learned special officer. You see through my login and see. He said, no, I will not. I want my own login. Now, para 7, can you see page 3 of the last minute which I have handed, 28 July. That is why we have mentioned, because the functioning of the form, para 7, page 3. Above that are the expenses. According to the appellant, the said entities aforesaid are creditors, and above quoted amounts are due to the firm. The appellant prays for immediate disbursal and submit that the firm will not survive if payment is not made to the creditors. Appellant submit GST bill for each of the creditors to prove the authenticity of the respective ledger GST given. Appellant submit the said entities are known to the respondent and in ordinary course of payment have been made earlier to the said creditors. 8. Respondent objects and submit he has no access to the Tally software books account and payment on such head should not be disbursed. Laptop and there is also recording next paragraph. We took the laptop also. Now, my lord, he is free to use it. I'm not stopping him. If he has lost the password, he has to take help of an expert and he has to again generate the password and access the GST portal as well as the Tally. Tally, everybody can access through their own respective passwords.
So instead of waiting for approval whenever someone wants, he can at least just take their opinion and independently decide and do it.
He has to independently decide. Now he is calling for meeting,
by looking into the papers which you have produced, the party who is seeking the transactions, you have to produce.
Yes, we have produced everything.
You have produced.
We have produced ledger, Tally data, printout, everything.
Satisfied that these are day-to-day required expenses.
Yeah, these are
according to Mr. Sharma.
He has himself recorded there is a delay of more than 1 year.
Let us speak. According to you, then he can at best take their opinion, but independently he has to decide and do it upon being satisfied.
Well, I am also that he did not take he has to apply his own wisdom.
No, he has to. That is what.
But if he has to, he holds meeting, he takes the object. They are objecting at everything, my
Mr. Sharma may not have to labor so much, my lord. This is a partnership dispute between two brothers, my lord. I have taken instructions from my client and I have tried to put in some sort of practicality into them, my lord. It's an arbitration dispute. Parties have to go to arbitration. Your lordship need not worry about each and every transaction and the special officer. Today, my lord, what we are saying, my lord, there were certain transactions pointed out for approval from the special officer for payment. It included GST payments. It
The
included
third
tax.
party payments, GST.
Yes, and third-party creditors' payments. My lord, that is all. My lord, we have made a compilation, perhaps, my lord, not required. So when they ask for these payments, we categorically state we have no objection to GST payments. We have no objection to statutory payments. As far as the payments to third-party creditors, my lord, it's a sari shop. Today, the partners want to dissolve it. There is a long-standing due of certain creditors for several years. Suddenly, my lord, those have come forward to be paid on at the first instance. My lord, now what I suggest, my lord, perhaps subject to your lordship's convenience, my lord, the special officer, the procedure that your lordship on the last day set out, my lord, for the parties is the best procedure that the parties can avail of till they subject themselves to arbitration. My lord, they have issued the Section 21 notice. My lord, Mr. Sharma is here. My lord, we can consent to an appointment of an arbitrator and come back to your lordship on the next day. Yes, my lord, in the
perform
interregnum.
it, we cannot stop
Yes,
the
my lord.
business.
My
My
lord,
lord,
in the-
kindly see the
Mr. Sharma, please.
My lord, in the interregnum, my lord, two things, my lord. If your lordship takes one email, my lord, I'll hand over the compilation just for one email, my lord, at page 30 of this
No,
compilation.
what we are proposing is that whenever somebody wants some payment to
Yes,
be made, special officer can at best take the opinion of the other side,
absolutely.
but then he'll have to take a call on himself, of himself.
My lord, no opposition to that.
Upon going through the
My lord,
papers,
no opposition. Your lordship
it
can
cannot
record.
depend on the
Yes.
consent of the
No,
other.
no. My lord, it
Well,
reads.
you also can ask for
It leads and or consent. He says and or consent. So, my lord, we are not fighting on consent. The special officer, let the special officer use its own wisdom. My lord, in the meantime, my lord, there is just one protection, my lord, because the parties are at loggerheads, my lord. We wanted only the GST login ID password and, my lord, the tally data. My lord, there is all the accounts are maintained on tally software, my lord. It's a
But
day-to-day.
as a partner, you must have your own.
My lord, so when we asked, my lord, we have lost the password, we have not lost the password, my lord. Today they have the password, they are doing the business. It is not that difficult, my lord, for them to assist us to that extent till the time we go to arbitration. My lord, if the accounts are provided and we are given the GST login ID password to see whatever payments are to be made.
Then what do you want?
Yes, my lord, that is at page 32 things, my lord. Just if your lordship takes page.
Tell us.
My lord, we want, my lord. My lord, we want the login ID password of the GST portal of the partnership, my lord. The login ID password to the tally accounting software in which the entire accounts are being maintained, my lord. And, my lord, the third thing, my lord, because we say that since 2025, the entire business is being run by them, which is also perhaps not in really dispute, my lord. We just want the accounts since that 1st April 2025 till date, my lord.
No, that will be beyond the order. Accounts that can only be asked for from a competent court has to pass by a court.
Very well.
We can direct accounts, arbitrator can direct accounts, but accounts you cannot. This order was only to just because the functioning was coming to a standstill.
Absolutely.
To avoid that, to bypass that, so that the partnership can function in the meantime, and necessary statutory and GST payments, as you rightly point out.
Yes,
fair enough.
These
So,
are the-
Mr. Sharma,
may I answer, my lord?
No question of answering.
Login.
Right now, it is not adversary in that sense. What about the login ID?
My lord,
of the
kindly we have
Please
given.
let us finish first.
Yes, my lord, may I answer that? I've understood.
I don't know the question.
If
you find that it does not answer our questions, we'll remove the special officer.
No.
keep
I'm
the
so
arbitration.
sorry. I'm so sorry.
This is impossible for us to.
No, I'm so sorry. Kindly tell the
Cannot
question.
pass any order if you go on.
No,
doing
kindly tell the question.
You can tell us for our questions first.
My lord, GST and tally password and login ID both have their separate. I enter through my login gate. He has his own login gate. Now, if he has lost, we told him that we have brought our laptop before the London special officer. Please see through my login gate. He said, no, you have to give it your login ID and password permanently to me. I will use it. Now, here we have said that you can generate your own. Why are you asking my login ID
These
and
are
password?
GST portal and
even
tally software.
Lordship?
These are not private documents of yours.
No.
These are the partnerships.
Correct. So we have given
why
them hard
give
copies
them
of
the login
everything.
ID and password? What
We
is
have
it?
given
They
the
own login ID.
they have their own login ID and
They lost
password.
it.
So they have to regenerate
So
it.
then very well, we'll stay our order till they get a new login and ID and password.
My lord, they have to regenerate.
We'll permit them to ask for that, and
My lord,
till
if
they get it, this.
my lord, they will never get it.
The intention is very clear, Mr. Sharma.
I can give them, but then
Thought that you would be able to solve the impasse, but if you are not willing to give the login ID password, then definitely you are saying or order appointing special officer. No special officer, nothing. You go
No,
to
we can give them, but it should be temporary. They want it forever. They want it.
once you give them, that becomes forever.
But that is the reason, Mala. That would then my login password, they will use it forever.
Login by ID and password gives access only to these partnership firm documents.
It is given behind the noted. I'm told the client has to. It is written behind the computer in the office. We have photo. We can show. It is everything is
If
written.
it's written in the behind the computer in the office, give it to them. What's the difficulty?
Yes, we
That
shall.
they in any event have access.
We will give
Give
that.
that password and we'll direct the special officer to take his own decisions.
Yes, correct.
Without waiting for sanction of the other side. No sanction is required.
Yes,
We'll
the
take
word
his
here
own
is written
decisions upon being
consent.
prima facie satisfied on the documents
Yes.
with the party wanting the
Yes.
disbursements.
And in just all hard copy, tally, ledger, everything given. We will everything all given to them. In
Learned-
all hard copies also.
Then senior counsel appearing for the appellant complains that pursuant to our order dated July 7, 2026, comma, a special officer was appointed, semicolon, however, comma, the said learned special officer is waiting for the consent of the respondent on each and every occasion when necessary disbursals and payments are being sought by the appellant in respect of the partnership accounts, partnership firm's accounts. Which of next para, learned senior counsel seeks to rely on the minutes of the meetings held by the special officer in that regard. Which of next para, learned counsel for the respondent submits on instruction that in principle, comma, the respondent has no objection to the necessary GST and statutory payments being made. Full stop. However, comma, the respondent merely wants the login ID and password of the GST portal and the tally accounting software of the partnership firm in order to have access to the same, comma, in view of the respondent, comma, who is a septuagenarian, comma, as is the appellant, comma, has lost such login ID and password. For some next para, learned senior counsel for the appellant submits that in any event, comma, the login ID and the login IDs and the passwords are available, comma, in the office of the partnership firm. For some next para, be that as it may, comma, the login IDs and passwords referred to are merely a gateway to have access to the GST portal and the tally accounting software of the partnership firm. And both the partners have equal right to have access to the same till the same is resolved and stroke or any order to the contrary is passed by any competent forum stroke court. Full stop. Thus, comma, in the event such details are furnished to the respondent, comma, in our opinion, comma, the impasse may be resolved. Full stop. Next para. Another aspect which is to be considered is that the learned special officer is apparently awaiting the consent of the other party when one of the parties is seeking a disbursal. Full stop. Next para. However, comma, we find the same to be counterproductive, comma, in view of there being little or no possibility of consensus between the parties regarding the payments. Full stop. Next para. Accordingly, comma, as a rider to our order dated July 7, 2026, comma, we hereby observe that the learned special officer shall, comma, upon receiving a request for disbursals from one of the parties, comma, shall at best take the opinion of the other party on the same, but shall not await the consent of the other party before sanctioning such payments. Full stop. The learned special officer, comma, for the purpose of sanctioning, comma, shall only look into the supporting papers and other documents, comma, if required, to justify such payments. Full stop. Next para. Secondly, comma, the learned special officer shall not hold consent in the event the nature of the disbursal is statutory, comma, including GST payments. Full stop, comma, however, comma, subject to prima facie satisfaction on the documents justifying such disbursals. Full stop. Next para. We also direct the appellant to furnish the login IDs and passwords of the GST post portal and the tally accounting software to the respondent at the earliest, in order for the respondent also to have access to the said portal and the software for the purpose of ascertaining the veracity of the payments. Full stop. Next para. The learned special officer and all concerned shall act on the server copy of this order for the purpose of compliance without waiting for a certified copy to be furnished.
Only one thing, in the meantime, let them at least start the process of generating their own. Let them, whatever time it takes.
Achha,
Let them start.
Nothing in the above order shall preclude the respondent from generating his own login ID and password in respect of the GST portal and the tally accounting software.
Got
Try to generate
Yes,
your
yes.
own password.
Yes, my lord, we should.
We can also help
Why should they
them.
provide
We
their
can also help them.
We shall. My lord, today the difficulty was that it was 2 days, my lord, the payment was to be made, my lord. We just wanted to see the accounts, my lord, that's all. Even today, my lord, it's a
Tally
partnership
is a very
dispute
good
for,
software. Tally, every reason 10% can log in.
It is for-
I also use Tally
My lord,
personally.
the
It's a very
entire-
nice software, very
the
good
entire
software.
dispute, my lord, today's
because of the
age, maybe.
magnitude of your payments.
No, not.
You don't have any idea.
No, everybody, even 10% can log in together. They have the different window for every person.
Not everybody's accounts do not.
Tally is a very, very, very
does not
interesting
require
software.
10% to log in at the
My lord, may I just, my lord, may they provide it in course of the day, my lord, because the payments we do not
we
want.
all-
earliest you have said.
We
It gets
are more
held up unless
Yes,
the
creative,
yes,
unless
that is the only.
unless the raw material suppliers do not supply, how will the sari shop function? GST payment will come subsequently. First, the business has to be
we
done.
have also put that in our order.
If
that
there is no
GST and
business, no
cess and
GST.
duties, they don't operate.
Yes, if there is no business, no GST will be there.
এগুলো রেখে দিন।
Grateful.
Deeply.
Next. Conflicts matter copy. বলা কি? না, আছে দাম করি। এইটা? সব তো বাঁধা রয়েছে। রেখে দিয়েছে।
The compilation the comparison পেয়ে গেছে compilation তোমার কম্পাইলেশনটা দিতে
এটা কালকে পাঠিয়েছি।
প্যাকেজ জিনিস পেজ নম্বর থাকে ওখানে পেজ নম্বর ওটা দুটো পেজ নম্বর May it please the Lord Similar. This is our petition.
Mr. Vikram starts, my lord. I would humbly submit, my lord. I understand he would take some time.
We will request you to be as brief as possible because
It will over today.
no, today means I mean if you can do it as early as possible because we'll take written notes of arguments from both parties if you indicate the points because frankly speaking we also have several CAV judgments to and other works. So if you can do it because it's Saturday you will have precedence, that's why you kept it on Saturday and it was asked for, otherwise we wouldn't have kept it on a Saturday. So if you can just be brief on your
Shall be very candid, my lord. If my lord, if it is restricted to notes, my lord, if I don't get my lord opportunity of hearing my learned friend, my lord, we are new entrants, my lord.
No.
That is
That
our
is wrong. That is
no, not only written notes.
a separate topic.
Mr. Mitra has substantially argued on the previous solution.
Twice.
He argued you have taken
That is
11
argued.
notes also.
Correct.
Not that
It
it's
appeared.
being taken up for the first time.
Yes, state definitely appeared.
Your name and the GP's
State-
name are there. It was your name and the government leader's name are there.
No, in the last
Huh?
occasion when it was adjourned, my lord.
I can brief করে দেবো হ্যাঁ I'll tell you brief.
It was adjourned and it was fixed for.
Oh, previously they
No, I had no idea that it has been argued, my lord.
It was argued and order recorded. It was said.
Order to order.
The state house subsidiary, they're only supporting that.
But subject to
Right.
correction, that was done perhaps at the time of obtaining Admission.
You're putting that.
Time of admission.
Yes, Mr. Mitra, let us hear it. Let us start here.
There are two applications filed by them.
I'll try to be brief. What we have done, my lord, we have prepared a compilation.
We'll hear arguments also so that you can get a
Compilation we have prepared, given the copy to them. In the compilation,
You have
we have
given a
mentioned, yes, we have mentioned.
Whenever it is. I have this.
Don't that, please, don't make a ground.
Huh?
In the compilation, we have selected documents where I have given the page number of that document in the paper book also.
fantastic.
Can
we have-
also
we have
find
also-
2 pages.
Give a copy of the compilation. to
Give
us.
me compilation. Lots of the due to copy. Is one volume will do. You'll have to find 2 page numbers.
Acha.
It was all out.
Convenience volume 2. Why?
Is only the judgment.
Only the judgment.
This is one. This is you are treating as one.
Yes. So Lordship, you hasn't hustled through the paper
No,
books.
thank
Lordship, you have 2 page numbers also. They have
We have what we have.
nothing, no new document, nothing. Well, may I humbly please?
All these documents are there in the paper books also.
All in paper book in several volumes, and we are given the page. Lordship, see the page number. Lordship, the 2 page numbers are there. The page number of compilation
Yes.
page
Understood.
and also the page of the document
Absolutely.
in the paper book also.
Understood.
Both are given.
No.
Good. No.
Sorry, sir. There were 2 CAN applications filed by them. Against one CAN application, affidavit in opposition. They have also used affidavit in reply. And for the other CAN application, like to use affidavit in
You
opposition.
are hearing the main WBL.
Of the last deeds.
You are hearing the main
Bole,
matter.
bole, ki direction
There was
diye
a
the to.
direction.
Main matter.
When this matter was fixed, your lordship, there was a direction to complete. They haven't completed. So, my lord, let us proceed.
Well, main application, main thing will proceed. It is all regarding mutation in the arrest records relating to.
I do not want to stop, my lord, the proceeding. Kindly don't take me amiss. My lord, here, my lord, I find, my lord, in the compilation, I was trying to look into it, my lord. They have mentioned one page, the page number of the compilation, and, my lord, the corresponding page of the
Paper book.
paper book. Now, it is volume 6 for this page. Volume 6, page 631. Now, my lord, of which paper book, my lord? I had 2 matters. Now, I really could not find, but
One set of paper book has been filed.
Combined paper book says.
One set of paper book. What keep paper book? It is not.
এই অনিন্দিতা আপনি দেখুন তো এটা কি একটা সেট অফ পেপার বুকস আছে দুটো সেট
Huh?
দুটো ম্যাটারের আলাদা দুটো পেপার বুক সেট
When the order pass, why it is? I don't know. বলো তো আমি আর
দেয়ার টু সেটস অফ দেখুন দুটো সেট অফ পেপার বুকের নাম্বার
one set of paper book. বার করে দাও। এই কি এই নিয়ে সব
প্রত্যেকটা পেপার বুকে দুটো নাম্বারই দেওয়া আছে টোটাল 22টা ভলিউম দুজন জজে দুটো কপি
বার করে দাও ওটা।
22 volumes one volume for each judge they mention both the writ petitions so it's a composite paper book one set of paper book yes
Direction there, one set of paper book will cover both. Nothing new.
the paper books mention both the numbers
Specific order is there.
that is sufficient indication
Minister.
Which was given yesterday.
Look at the order.
what about that
This is not the ground for adjournment. Take a better.
I am not, my lord.
Then may I start? May I
It
start?
is seriously hurt
No,
I don't do that, my lord.
you should.
No, you did.
No, you would not. শুরু করি এবার with your kind permission. শুরু করি।
very sarcastic so you should respond
Always.
we'll spend our time
May I say?
let him start Mr. Shurjitnath Mitra let Mr. Anindya Mitra start
Order there.
there are one set of paper books composite what we gather and these two convenience compilations you also got it yesterday you also got
Same.
Paper book
No.
গুলো কোথায়?
And compilation for their convenience. If you do not want, they can refer to they can hustle through all the volumes they'd like to.
yes
That may humbly have been. The point is very short matter. mutation of the RS record relating to a plot with number is 104.
Yes.
Mauja Golakata. That's it. That we purchased this lot of land from BP Foundation, that foundation, whose name was recorded in the municipal record. This municipal number is given 115 Golakata Road. This is the road. We found in 2011 we purchased for valuable contract. We have discovered that deed of conveyance also. There is a deed of conveyance. We purchased for valuable condition, a valuable consideration from BP Foundation. 2011, we found the name of BP Foundation was recorded in the municipal records as owner and occupier possession. So we purchased and we got vacant possession.
What is the date of your purchase?
Deed of
What was the date of your purchase?
giving loss of date of is 26th May 2011.
Very
The document is also I can give you.
No, we'll look into
26
it. Just for
11
ordinance, yes.
26 May 2011.
So you purchased Golakata, 115 Golakata Road, you found BP Foundation's name there in the RS record.
This was at that time municipal record, premises number allotted, and the municipal records, they were the recorded owner and possession, owner, occupier. And we got vacant possession, no dispute. In this matter, also find there is no dispute, even up to the tribunal stage, that we are in possession. And the party, this party Barjut, who wants their name to be mutated, they are not in possession. Barjut has filed a title suit in Milord year 2013. Title suit, making us a party. And they are claiming the title to this property, ownership title, and they are also recovery of possession from us. Recovery of possession from us. So, Milord, if they win the suit as an owner, and recover a possession, they can get the suit.
The suit is still
pending. Suit is pending, and interim orders have been passed in the suit also.
So they admit your position by filing that.
Admitted. The prayer is for recovery of possession. And not everybody, all the orders are placed.
Upon purchase, you want your name to be recorded?
Yes.
You wanted your name to be recorded after purchase?
No. My name has been recorded in the municipal record, all right. And this record of rights.
Birds now wants to.
Then when, how tell you why? When they were this after he purchased, then the trouble started. They made a Barjut started initiate proceedings for change of municipal ROR, record of rights. Record of rights, then not in, if I go back, then a flashback like cinema, we find a lot of proceedings that taken place before we purchased. First proceeding, now I give you a serially the proceedings regarding record of rights and the purchase, etc. I confine myself only to the orders. Now, the first dispute arose from the record I find in 1998. That was the record of rights, RS, was the name of one Kashi Prasad Singh. Their heirs of Kashi Prasad Singh got their name mutated, but they are not getting the parcha. So they filed a writ petition in the High Court. And they made Barjut a party. Why? Because Barjut are objecting and saying that we are the entitled to be record of rights. That matter, my lord, came up before the High Court writ petition. They have this Kashi Prasad Singh's heirs, they produced a parcha showing their father's name, Kashi Prasad Singh, as a riot recorded in the mutual. And then Bardut also produced a Porcha showing that their name is recorded in the Porcha as the recorded document. So this dispute came to High Court. High Court, Honorable High Court found, yes, this is a two Porchas cannot be different. So High Court directed BLRO to make an investigation and find out which one is genuine. Let's see the order. This is now relevant portion starts. This is the order of the High Court. Let's kindly come to page 91 of the compilation. Order is dated 24th September. My compilation. Page 91.
No difficulty, we can follow from here. Yes.
Compilation.
Yes.
The right hand pagination is it compilation page.
You have seen it, Mr.
Just a
In the circumstances, I direct
short,
BLR to
short,
take up the application.
short order.
Yeah.
Now, pursuant to order, matter went to BLRO,
Yes.
who heard both parties.
Yes.
And made a report or BLRO. This order is at page 100 of the compilation. 100A, my lord, look in it, a typed copy. Will be more convenient reading. Page 100A, which is also at page 196 of the paper books. This is dated, yes, BLR order is certified copy. 13 November to 1998. Seen all papers submitted by both parties. Examine all available office records. Two contradictory certified copies in connection with Kotia number 72 of Moita Golakata have been submitted by both parties. Hence, I have to rely upon the official record. The reconstructed Khatian, which has been prepared on 8th April 1985 in the name of Sri Kashi Prasad Singh, son of Rambali Singh, is taken into account. The mutation made by JLRO Khatian appears to be genuine. So genuine. But as LR work of the said Moja has not been taken up, the petitioners may appear before the LR, before the KB, for as the sex.
Who are the petitioners? These petitioners were Kashi or Kashi's heirs or?
Yes, Milord. The Khanapuri Bujadat. So, Milord, they say that
Petitioners were Kashi's heirs.
Milord.
They may approach the.
So, Milord, they found our Parcha of the heirs of Kashi Prasad Singh is the right one. But they say, I'm not making now order because LR is coming to apply waiver, getting your name. So, Milord, this is the first thing court found.
Yes.
And the BLR found that the Parcha which has been prepared or brought by certified copy of the Parcha which brought by Barjut was not a genuine document. This is the first non-genuine document produced by them. There will be more. First non-genuine. One thing, Lordship, I'm humbly at, this order was not challenged. Report of BLR was not challenged. They dropped, relying on their own Parcha. So, Parcha, this genuine one remained. Now, this is in 1998. Thereafter, we purchased the property. I told you without knowing all the details. Anyway, then, we found after we purchased what then initiated proceedings. An order was passed, supposed to be Suomoto by the BLO. Next BLO, other BLO. Is long after that. This is the genesis beginning. When I come to see the order dated 4th February 2016. Suddenly this order is passed, that's which you come to know later on. 4th February 2016, page 168 of the compilation. The type, but the next page is type copy, you also find typed also.
168, there is no typed copy.
169.
169
The next typed copy will also
That's great. We thought it would be AN.
Whereas it appears that the advisor SP Mukherjee of Barjut and Export Limited, having its office at number 4 Netaji Subhash Road, submitted in respect of not bona fide recording against their landed property, which originally was recorded in RS Khatian number 41, plot Andamuja Golakata, jail, comprising 54.12 decimal, half acre, more or less. I tell you, with the premises we purchased were 22 katas out of this. And this is our dispute regarding the 22 katas. Matter has previous facts, which is necessary to describe. Page 171, Miller, skipping one page. As per submitted documents, it is ex parte without notice to us. No notice was given. And the complaint appears to be oral complaint. It doesn't say any written complaint, written petition. From the order. Some to advisor of Barjut, Mr. SP Mukherjee, see, he submitted in a respect. Yes. I am not notice given. I've been then not reading what the basis of the order. What's the basis of the order? As per submitted document appears, the entire matter brought into concern of competent authority before 2014. Thereafter, a letter was issued from the end of Jiden ADM, settlement officer, and DPA, by memo number given, dated 16 January 2014. It appears from the said letter that the authority concerned imposed direction to set aside the bad recording which was directed at this end and was reported accordingly. Authority ADM directed. As per the said letter, Jiden BLRO was directed to draw up proceeding on Section 47 of the State Acquisition Act regarding modification of RS Khatian number 41. Page 173 now. It was also directed that the plot number 104 was recorded in favor of retainee with a noting of Section 6 by subsection 3 by government order dated blank. It is blank in the order. Date is blank. It is not omission to put it. Blank date. But surprisingly, it is observed that the before mentioned order was not complied with at that time. Now it is necessary to initiate a proceeding so as to the record of rights in respect of plot number 104 to be restored in favor of original record holder, Lansdowne Youth Company Limited, Pokhe, Managing Agent, Bard and Company, Chartered Building. After cancelling the recording which took place in quotation number 72, anticipating the granting of the matter, the undersigned reported to ADM and DLRO, and again order was issued by memo number such and such dated 8 January 16. That's the date I have given to you also. In respect of the above mentioned discussion and information, erroneous recording in Khatian number 72 is to be declared cancelled. It's erroneous assumed to be. And to restore the recording, RS number such and such. Hence, Khatian number 72 is declared cancelled, being void ab initio. At the same time, RS Khatian number 41 being reconstructed is modified as per previous provisions of Section 47 of WBEA Act. And then, last page. Then, in favor of Lansdowne Youth agent managing a Badan company in newly opened modified Katiyan. Thus, direction ADM is complied with. On the same day, correction was made. Now, what is the basis of the order? First thing Hamli pointed out clearly, my lord, there is no consideration of possession. Who was possession? Who was in possession? That the named recorded person name that they were not in possession. Possession aspect not considered. And mutation of record of rights, that is the most material and perhaps deciding factor. And it is based, BLO Act, on the basis of an order of ADM. Issued in 2016. Issued to 16. The order of or section 63 is not mentioned here. It is blank. Subsequent lawyers will find they claim order was dated 1964. I come to that merit later on. That order is non-existent anyway. So, this order of BLRO expressly suffers from the vice of non-consideration of most relevant factor, namely possession, and simply basis is direction given by his higher officer. That is cannot be a basis for. So, it is not an application of independent mind by the BLRO. No independent mind. Now, we came to know of the order in a proceeding in the suit. In the suit, this order came to know. So, we thought regular appeal should be before ADM, the district settlement officer. But since he has directed, we appeal straight to the tribunal. And tribunal rejected appeal. Now, that rejection was done, then he filed a writ application before Honorable Court. Honorable Court passed an order on 19th November 2018, page 186 of compilation. It suggested the order on the ground of natural justice, page 186, upon hearing all parties. That order starts at page 186. November 20. Lord, you find the government appear to the landed GP and Mr. Supratim Dhar responded for that. Now, kindly reproduce the order.
Respondent number 4 is the present respondent.
Respondent number 4 is Badjut. For it, Mr. Dhar appeared, and he is also now appearing for them. Directing a judgment and order of that tribunal, he mentioned. Then, tribunal is approached by the petitioner to examine a short point, whether before affecting modification or alteration records of right by the order dated such and such, by substituting the name of the petitioner with the name of the respondent 4, the BLRO of respondent 3 was under an obligation to give notice to the petitioner.
Or the alternate party in violation, so set aside.
Okay. By your considered views of the correct, then what they set aside on that ground. And direction was given. Kindly take the direction.
Give hearing and reasoned order.
189.
Upon hearing, reasoned order to be passed.
Yes. Order upon both hearing,
Yes.
I will note it, and then direction is important.
Yes.
There is no page 189 can come to. No opinion is expressed on the rival claims. All points left open. We take on record a report of the Amin, dated census submitted before Mr. Majumdar. It record there exists a partially constructed building, 1.5 story on the property in question, and that building materials like etc. But we after we got a building plan sanctioned, and we have started the construction. So this is also noted. Then matter is to be heard by the BLRO. Kindly come to page 188. The direction. Response number 3 is directed to make himself free, and that hearing was given. Now, same BLO matter came back to him. Now, they gave us hearing this time. After giving hearing, second order of the same BLO is dated 4th February 2019, page 250. 250G. Can you come to 250, Milord? Because the time, because G can avoid. 250G.
Paper book, page number is 519.
Paper book,
250 series as ABCD and
G. Paper book volume is 519. Volume 5, paper 9.
Thank you.
No.
That would help us.
See, Milord, what is the basis of this order? Again, that you'll find it is no possession aspect is not considered. Again, I will not say anything. Read the order and find yourself. As per perusing the documents submitted by etc. and taking admission at Harding Commission available record, I find the following. As per copies of GS Katya number such and such in respect of plot number 104 and also others Katya is provided by BGL and Katya, we were in the name of Lansdowne Jute Company Limited. As per reconstructed RS Kotian 72 of Mouja Golagata, available in Mouja volume, etc. in the office, the same is found recorded in the name of Kashi Prasad Singh. But no reference Kotian number is noted in the said Kotian, which may disclose the origin of the said RS Kotian number 72. It only appears from the noting made in the Khatian that said RS Khatian 72 was reconstructed by tone case number 29291, etc. Note, this is the finding given by the BLRO that this is genuine. Other one is not genuine. And there is no dispute regarding that finding.
Which is genuine?
Hmm?
Yours.
Yes, yes. BLRO, and no dispute. But this BLRO is now sitting in.
Yes, the previous BLRO said that.
Sitting in different. Saxon Inter Kashi Prasad Singh filed a writ petition and High Court order is noted. Taken the application petition at the time of considering High Court note order from the copy it appears, Response 4. Another comment was made, Response 5. Party was there. Then the paragraph 4. Document submitted by the Rototron, that is our client, as the proceeding miscellaneous was initiated. Then the reconstructed Kotian, which has been prepared on 8/4/85 in the name of Kashmir Singh, is taken into account. Mutation made by Gelado appears to be genuine. That order was shown. We have seen their order. Then, Milord, one SP Mukherjee on behalf of Bard Jute Export Limited filed a letter. Now find the letters. The letters now come on the record, which is not mentioned in the original order. A letter now brought in. 2 letters, where the application bears allegation for not providing information respect to which plot number 1 as well as Khatian number, etc. measuring in the said application, it was also stated land was allowed to be retained by the state government on Section 6(3). That is, an illegal case of mutation or subject case was held and recorded by a third party. Now, this was all gone into by the High Court of previous petition anyway. On the basis of letters above, now Willard refers to letters. This then BLRO initiated the proceeding by case number such and such, which are disposed of, name it, cancelled and mutated. Then Willard kindly, background is order motion. Meanwhile, tax interest of the state Kashipur Singh transferred the land that is sold to BP Fadda, that is also noted, to one BP for that foundation, thereby several registered deeds and said except, and transferred 22 katas of land, self-same plot to the applicant. Out of 22 katas, also that is noted, sold to us, Rotterdam
Mr.
contractors,
Mittal,
in the year 2011.
if you can please come to directly to page 260,
Mm.
because there the German findings come.
Yes.
After this discussion, the preliminary findings at page 260 of this compilation
Actually, I gone through this. Yes.
and
260 বলছে last এ।
260.
0
Hmm.
260 আরো পরে।
Can you not come to
260 paper
yes,
529.
conclusion portion? Yes. Operative part. Yes.
Back to the operative, the preliminary findings on the basis of which the findings were made.
That is,
3 4 যেখানে আছে।
that kindly you
আরেকটা পাতা।
come to conclusion start at 260. Conclusion. That is heading conclusion. This conclusion in respect of my finding is hereby drawn that.
No, before that,
Page 260.
260 in our copy, the rounded 260.
Rounded 260
529.
That is portion of this is
Number 1, 2, 3, 4, your lordship will find the same.
As the conclusion. We thought there is a heading. Wait, wait. Please
this is
continue.
that portion I did only.
Yes.
The Lansdowne Jute was recorded in CS record, cadastral. Then as status was Muddho Shatto Adhikari Chirasthai, intermediary. Yes, very good. Retention was allowed to the said Lansdowne by order dated 7th April 1964. And the ADM letter is of 2016 to give effect to it. Indicating the head company is in possession, indicates head company in possession on the cardinal date of vesting, and since the cardinal date of vesting comes under purview of 6(1)(g), Reddit Westman Act. With regard to the observation made above in respect with framing of RS record of rights, and on the basis of the documents produced herein, it may be asserted that the said Lansdowne Jute Company should have been recorded in RS stage of operation as intermediary under the state coming under 60 order under section 60. The order is the basis. Now, it is found in reconstructed orders obtained from Mauja, volume of this office, that Kashipocha Singh is recorded as Rajat under section 4 of Estate Acquisition Act, which draws the simple deduction that Kashipocha Singh got the suit land by any lawful means and got his name recorded accordingly. Now, Kashipocha Singh could have procured the suit and only by two means. One, by a direct settlement with Emperor of India, and two, from Lansdowne Jute Company. How they do not know. Either by lease or by transfer before promulgation of Act, as the suit land is having affected by section 60 of the Estate Acquisition Act. This is fine, totally disputable to find that suit land is not affected. Question is not, he is going to title now. He is going to title. So is that at all permissible? Not at all transferred in lease. DC would be deemed to be directly under the state. No question given. They may not. The next paragraph 5 is important. RS was produced, paragraph 5, in course of hearing, a reconstructed Khatian bearing number such and such, in the name of Kashipocha Singh, obtained from Mauja volume, another bearing name of Lansdowne, provided by BGL. Both are being produced, which already decided that produced by BGL is not genuine. No. In respect of RS, in the name of Kashipocha Singh, it appears that though CS number was rent-free Khatian, rent is fixed at rupees 3 without any cess. Now, fixation of such rent-free land is not only contrary to the provisions of section 42(1)(c) of the Westminster Act, but fixation of rent without cess, exemption of cess, is not at all legally tenable. Moreover, the status of the state Kashipocha Singh is found recorded in the reconstructed Khaitan as Rayat under section 4, which is not possible, keeping in view the discussion made in paragraph 1 to 4. 1964 Act the order was supposed to have been passed. With the Estate Acquisition Act 1955, the record of rights RS on 1955. Number next B. In respect of RS number 72, it appears the status of a said Lansdowne Youth Company is as recorded as Rayat under section 4. Now it is held that following the issuance of order by it, etc., suit plot came under the purview of section 861G, Reg 63, and under no circumstances can be treated as Rayat under section 4. So they are not. Hence, the framing of RS number 2 produced by BL is not tenable in the eye of law. He should have said in eye of fact, because the court said it is not a genuine by his report. So, but they consider that this is the order he passed. We order is not Calicia order portion 260, hence order RS number 2 containing the name of Kashiputta Singh as found with Mauda volume, etc., be prepared with modification in the name of Lansdowne Youth, Pokke Managing Agents, Bar Chartered Building, with due noting of retention order of 6.3 of the Act. Now, through 60 order, Milord, that order came later on. So, came in 1964, I can now find that. And after 1964, up to Milord, the matter being had 2018, there has been no change in the record of right on the basis of that order. In 1998, Milord, when the matter came up in the High Court writ petition, no reliance on the 6.3 order. Question was which purchase genuine. Not that no question was raised that 6.3 order they are entitled to be in possession. Nothing. So Milord, here also again, order of very humble submissions, I found very material fallacy. Possession is not considered. In fact, possession of Kashiputta Singh and yes is not disputed. Or if later on find is not disputed by etc. And only because of an order, 6.3, whether it could be done. It's a mutation case. In a title suit, let them rely on it. Question arises to find that there is no mention of the original order. It all referred to a copy order. First order, the date was blank. Now date is filled up, but what is produced? Copy order. And copy order similar, not even signed. Anyway, that will come to different aspect. But not my humble submission, ex facie, this order is vitiated because most material aspect for mutation of record of rights, namely possession, is not considered, and they're aware of that. Possession with the Kashiputta Singh's heirs in at that time, and now BP Poddar, then myself, etc. So this order cannot, in my humble sense, stand and have any legs. Now, from this order, question arose whether this order could at all be passed under section, under which provision is passing the order.
Section 47.
47 would not apply. Can you see the section 47?
Yes.
Just pausing here, Milord. Then
That's just for recording, eliminating the names of the intermediary.
removal of intermediate.
No, but something has been made out here that that land was retained by Lansdowne. So if it was retained, in any event, section 47
land was allowed to be retained by an order under 6.3, correct?
Yes.
But land was actually retained, that should be in 1964.
The forms whether those are filed.
Then even after that, this record of right continues in the name of the Kashi Prasad was the Rayat,
Yes.
and when the revision of this record was made, was the Rayat, as Rayat continued under section 4 Rayat. That is noted under Westminster State Acquisition Act. So, my lord, the name continues under Section 4 of the Acquisition Act in the name of a riot. Intermediate interest all gone by the Act. By the Westminster, even if that intermediate interest, as earlier, that Mudda Sattodhikari and the CS DAG number, that is gone by us in 1955.
That would be subject to retention if they retain.
Subject.
But retention, there is nothing.
Hmm.
Because this is not also Section 61G has been, so this was a mill or factory,
Yeah.
jute mill.
Nominal
সুতরাং ওটা
Section 47 of Sulci.
661
47 definitely have a very strong ground there. 47 is probably one of the best grounds here.
Section 47 can be similar.
That we have seen, Mr.
It doesn't apply at all.
লাগে না লাগে
The right of intermediary to retain certain lands under 61G
এই যে 6 কি হচ্ছে
The 61G,
subject to provisions of
subject to provisions of Section 3,
and
land comprised in mills, factories, or workshop.
এবারে 6 তে গভর্নমেন্টকে দিতে হবে
Then they come to 3. In case of land comprised in a leek tea garden or mill, that is a mill, jute mill, factory or workshop, intermediary, or where the land is held under a lease, etc., omitting that, shall be entitled to retain only so much of such land as, in the opinion of state government, is required for the purpose of tea garden.
একটা 6 অর্ডার দিতে হবে গভর্নমেন্টকে
Hmm.
অটোমেটিক রিটেনশন হবে না
Not automatic retention.
6
It will be retention which opinion has to form by state government that it is required for the mill.
পুরোটাও দিতে পারে কিছুটাও দিতে পারে
So much of land as is required. Suppose you're holding 100 acres. But government think 100 acres not required for running of the mill. 5 acres will do.
ওইটুকু রিটেন করতে দেবে
This is one thing. But my lord, may I humbly point out another missing link. What is the finding? That this order relates to plot number 104. Now let's see the copy order which was produced, which is now being produced. How it relates to plot number 104 of Mouja Golagata.
377 এ আছে
Now let's do fact. See the order, copy order, Daka. Just showing it for time being. What's the order? Then so now let's kindly
377
the mill premises now bear municipal number 200 Dokhindari Road. Mill premises. And this plot number 104 bearing number 115 Golaghata Road. Now let's see. Just
377
can you come to page 377 of the compilation? Then I will come back to this order. Nature, we have proved that hill, it is a non-existing order. 377, typed copy, 378.
সার্টিফাই করেছে বার্ডের ডাইরেক্ট
Oh, sorry, can you see second 377? Certified true copy, Bard, Jute and Export Director. They have certified to be true copy.
বার্ডের ডিরেক্টর
But director of Bard Jute, not by government officer.
ওই এভিডেন্স অ্যাক্ট
They not seen the typed copy for reading purposes. Whereas land measuring more or less 2.78 acres, huge land, comprised in the mill, can you mark the part, held by Messrs. Lansdowne Jute Company Limited in Mouja, Golaghata and Ultodanga jurisdiction. This number 27 and 26 respectively. Police station Damdam, District 24 Pargana, vested in the state government, free from encumbrances under Section 5 of the Estate Acquisition Act. And whereas after inquiry, state government is of the opinion that 52.73 acres of land is required for the purpose of the said mill. It is comprised in the mill premises, Kalimon. Now, therefore, in exercise of the power conferred by the etc. Section 6, government is pleased to declare that the certain 52 acres of land being required for the purpose of the said may be retained by the said mill in accordance with etc. So there is no enclosure to this order. Order is SD, not signed. Anyway, but how this mill premises then comprise the mill premises? And that relates to 104. How does it show? It doesn't show. There's no discussion, no. You have to link this order to plot number 104 before the Baylor could pass any order. There is no enclosure to the order. This was the order produced on his acting. Now, I shall go back to this. We prefer an appeal. We treated this order to be another section 42, 2A. Can you see the section? And please say the section. The question of intermediary dispute. We took the perhaps my client to advise if any order is passed in the wrong section, but if there is a section empowering, then that will read as that. 44 2A. देखो तो. Can you see? Draft 44. When I'm reading 44 whole of it, my lord, can you permit? When a record of right has been prepared or revised, the revenue officer shall publish a draft of the record so prepared or revised in the prescribed manner and for the prescribed period, and shall receive and consider any objection which may be made to any entry, either to any omission therefrom or during the period of such publication. When provided that no order passed on section 5A shall be, that is not relevant here. When all such objections have been considered and disposed of, and according to rules as the said government may make in this behalf, the revenue officer shall finally frame the record and cause such record to be finally published in the prescribed manner and make a certificate stating the fact of such final publication and the date thereof, and shall date and subscribe the same under his name and official designation. But this took place, that I'll give you the exact date when the revision was made in revision, others record was published in 1955. The record is there on record, and the date 1st August 1955. And that the document is not page 37 of the compilation. Can you see page 37 of the compilation? We have annexed the porcha. Yes, 8 of them. Similar page, kindly page 47. 37. 37.
Yes, yes.
The similar, the 24 Parganas, Mauja Golagata, the top. Khotia number 72. And is South Domdom municipality Bukto, that is also mentioned. Poschim collector.
পশ্চিমবঙ্গ পক্ষে কালেক্টর
Collector. And then next, 24. Then Rayat, Kashi Prasad Singh, Peter Ramjin, and this government. Sakin Dokindari, and recorded.
Residing.
Record of rights. Then it is
4 নম্বর বিধি মতে রায়ত দখলি সত্ত্ব বিশিষ্ট।
Then on the right also find 4 নম্বর people বিধি মতে রায়ত দখলি সত্ত্ব বিশিষ্ট রাজস্ব কর্মচারী. This is a date is given. Date is ডেটটা কোথায় পাচ্ছ? ডেটটা কোথায় ছিল? ডেটটা আছে এখানে। Huh? And the attested, one, the date is in the middle, attested, sign eligible, SD 1/8/1955. Is certified copy. So, Milord, under, it was done under 44(1) and 2. Then, Milord, kindly see 2A.
60 years even for suo motu.
2A. Separate publication of different pages, that is done. 2A, Milord, kindly show. An officer specially empowered specially empowered with the government may, on application within 9 months or of his own motion within 60 years, is amended, 50 years became 60 years in 2007. 2007. Anyway, from the date of final publication of record of rights or from the date of coming into force, whichever is later, revise an entry in the record of rights. Fine. What is the gap? 1st August 1955, and the order of BLRO, second order of BLRO, is dated second for February 4, 2019.
16.
2019. February 4, 2019. What's the time gap?
64.
Huh?
64 বছর।
After 64 years. Order of mutation given after gap of 64 years. If 2000, even 50 years extended to 64, because at that, on the date it has come into operation. (64 years). That's why we have 47. They knew that they could not do it under the law. Time gap. May I? This is an objection which will elaborate later. Now, may I read on this remaining part of the section below? Provided that nothing in the foregoing paragraph shall be deemed to empower such officer, on 5A, I am not applicable, I am omitting that. Second proviso can read. Provided further, no such officer shall entertain any application under this subsection, or shall his own motion take steps to revise an entry if an appeal against an order passed by a revenue officer or any objection made on subsection has been filed before the government. I omit that. Can you come subsection 3? Any person aggrieved by an order passed in revision under subsection 2A may appeal in the prescribed manner to the tribunal appointed for the purpose of this section, and within such period, so appeal will lie to tribunal. But please now see section 3. Now, kindly come to section 53B. 53B. 53B now? 55B.
57B.
57B. 57B.
Yes.
Where an order has been made under subsection 1 of section 39 directing preparation of revision of record of rights to the civil right, no civil court shall entertain any suit or application. Subsection 2. No civil court shall entertain any suit or application concerning any land or any estate or any right in such estate if it relates to. Alteration A. B is important. It relates to dispute involving determination of the question, either expressly or by implication, whether a riot or an intermediary is or is not entitled to retain under the provisions of this Act such land or estate or right in such estate as the case may be. That was the dispute involved. is a specific and any dispute.
The civil court entertained this. Where
Well,
does the civil court come in here?
What is order? Supreme Court. Okay. No. That is not civil court. May not.
This is
They
the Bharti
filed a
civil
suit
court.
earlier, 2013. Already filed a suit. Already filed a suit, 2013.
Even B2B is not.
The suit has been entertained by civil court.
cannot sit
Claiming. Huh?
Subsection 3.
Yeah.
3 or 4.
Suit entertained. I'm not a question of maintenance of that suit. That will argue in that suit. Now, can you see subsection 3, on which I am relying? Any dispute referred to in clause B of subsection 2 may be decided by a revenue officer not below the rank of an assistant settlement officer, specially empowered by state government in this behalf, who shall dispose of same in such manner as may prescribe. Then, proviso I am not to reopen any matter which has already been intended, that not. 4. Any person aggrieved by decision of the revenue officer made under 3 may appeal to the prescribed manner in a not below rank, etc. within such time, in such manner as be amendment. Then appellate authority can go. Appellate authority is tribunal. So, if a question arises, even by implication, whether a riot or an intermediary is not entitled to retain under provision of, let us say, section 6(3) or section 1G, 1G, such land or estate in such state, their dispute has to be settled by settlement officer. So, on the basis of this, we filed an appeal before DSO. Now see the appellate order. Can you see the DL appellate order? Appeal was filed. Can you come to page 305 of the compilation? 305 of the compilation. Sorry, order sheet starts at 305. Order is at page 307. This case is put up for final order. That brief facts, suit land, edits, etc. 54 committed. CS land classified as bill, recorded in the name of Lansdowne Youth Company. As per ROR, RS ROR, which was available to the custody of the BLRO, Barakpur, land was recorded in the name of Kashi Prasad Singh as Rajat status and classified as Danga. Mutation was once done.
Yes.
Mutation was once done by inheritance by the then JLRO, by the order, etc., in favor of legal heirs of Kashi Prasad Singh. This proceeding was unchallenged. In W. Writ Petition number, Honorable High Court directed of 1998 Writ Petition, the BLRO to take up the application of the petitioner, Ravi Shankar Singh, the son of Kashi Prasad Singh, and dispose in the accordance with law. However, Honorable Court made it clear that BLRO should not adjudicate any matter related to forged and fabricated documents. Due to non-submission of any copy of the writ, the contention of it is not clear. The writ was not there. Accordingly, BLRO initiated proceeding on 5th May 1998 and came to a conclusion that the mutation case is genuine. No one challenged this proceeding. This is one. Meanwhile, successor in interest of the Kashi Prasad Singh transferred the land to BP Poddar Foundation Trust, from which Rotterdam appellant in the instant case purchased the same with the benefit of sanctioned building plan. A miscase proceedings was numbered under section 47 was drawn by the BLRO and disposed of the same within cancellation of others number and minute order seen. Number, this is recording. Next, Honorable High Court set aside the name of learned erratic. Set aside the order in the BLRO priest. Now, then also was seen that then kindly can order portion, last paragraph. Learned applicant, we have a respondent, that is Bar Jute. Number 2, that is number 2 is Bar Jute, claimed that CS Khatian was prepared on behalf of Lansdowne Jute by virtue of a resolution adopted on 27 October 1971. CS record prepared in 1971. Huh? The name of the Lansdowne, was changed to Bar Jute. The appellant has failed to produce any paper with regard to establishing title over the said fruit land. He said, that's the contention, not title. He said that the Khatian was answer wrong. Then, my lord, respondent said, judgments are cited, kind to the conclusion portion. Our submission is given that conclusive possession of a fruit land not in dispute. Please, Miller, come to the order. Order is that starts at page 313. After noting the judgments, first, this court has no jurisdiction to decide the title over the suit land. This is the first thing. Like Hamza, this cannot be disputed. This court can only deliberate on the corroborated correctness of the revenue records, and possession is very vital to frame the other work. This court ordered BLRO, Barakpur, SDO directed, to submit an inquiry report over the suit land. Accordingly, he submitted the same on due inquiry. It is not necessary to give opportunity of being heard before filing of inquiry, as it is a field of inspection. Then, as per report submitted, it is observed that was no existence of factory on the said plot, and the jute mill and the said plot are different maujas. This is a field inspection report. The appellant has possession over the suit land, and same was admitted by respondent 2 during course of hearing. Because then the suit is for recovery of possession.
What's the respondent number 2? What was the respondent?
But respondent 2 is Bar Jute. Bar Jute respondent 2. As you have seen that earlier also, respondent 2 arguments have been noted.
Yes. Right.
Then apart from the report, then first 2 grounds, title need not be gone into, and field inspection report shows who is in possession. And it is not comprised in the mill premises. Land is not comprised in the mill premises. Different maujas. Apart from the report, it appears respondent 2 by title suit number 42 prayed to the appropriate court of law for recovery of possession. This matter is pending. This is to be reiterated. The title of the suit land will be decided by the appropriate court, filed by them. But it supports to come to this conclusion that the respondent number 2 is not in possession. The approved building plan and the holding number issued by municipality also support the possession of the appellant over the suit land. This is my possession part. Then, next, on the point of 6.3 of the said act, it is argued that respondent number 2 got the retention order from the department. However, respondent number 2 has failed to produce the original annexure of the said order, despite being given ample opportunity, and also the copy of the annexed land schedule of the detention order produced does not bear any signature of the appropriate government authority, and the calculation of total area mentioned therein is erroneous. Hence, this court is not satisfied over the detention order submitted by Resolution 2. May pause. This is very important. He finds that the original, as shown in your lordship, original is at noted page 378. Anyway, you've seen that it does not bear the signature. Sorry, order doesn't refer to any annexure of land schedule.
Yes.
But the copy they produce now before the DSO, that contains an annexure. That kindly come back to 378. 379, that's what order 378 order, no enclosure, but 379 is annexure. Annexure. They're giving the details of the land. And she certified by whom? Certified to copy by Barjut. Annexure. The next page also was same. It did not come out. It's all that. Currently past 381, certified true copy Barjut. Then if it did not come up original, then we can 385. That and the seal of Barjut also there. Now 385, I should point out here, Milord.
Yes.
All certified true copy you see. At towards the bottom of the annex you'll find reference to plot number 104.
Yes, 104.
5432 Danga. এটা কি লেখা? ডু মানে খতিয়ান number. There in this annexure, they have included plot number 104, measurement same, Danga. এটা কি তারপরে পড়তে পারছি না। খতিয়ান নাম্বার পড়ে দাও না ভাই।
72 খতিয়ান তাই জন্য
ও টাইপ কপি আছে। এই তো টাইপ কপি আছে। 386 better reading. I can add this read. Puja Golakata, serial number 104. It is encircled by somebody, by us, I suppose. The area is mentioned 5412. It tallies. Danga, all right. Then Kotian number 72. Are it a key? 2 taki. And
Survey
this
sheet?
is
Heading at the top.
Survey sheet, SC.
SC. That's the key money. Anyway, I don't know. Anyway, this is all. Annexure is not mentioned in the order,
Yes.
and annexure is
Certified by them.
yes. This is well, that's why I say
Company
stamp. Yeah. Yes. Yeah. So, can you remember the first? They have fabricated a parcha, which was not found, which found to be not genuine. Now they have. This is well, therefore is the reason given by the DSO acceptable? He has commented on that. How can rely on an annexure which is not certified by the government officer? That's the reasoning. Does not bear any signature appropriate authority. Urdu does not bear signature appropriate authority. And the calculation also is erroneous. It is not the total is not 50. Sorry.
Telling. Let's come back.
Okay. That I will show later on.
Yes,
Total doesn't tell. Would you?
Yes,
May.
please. Yes,
Well, I placed the order of DSO, let us summarize. The two things.
yes,
First, he called upon them to produce the order on a 6-3
yes.
and annexure. And he record they have failed to produce the order annexure signed by the government authority.
Hmm.
From that, we will cite letter and judgment to show that official records or order loses all presumption of correctness unless it is certified original is produced or certified copy is produced.
Yes.
Here, but the government later on joined the fray. Even the state government, my lord, before even the tribunal, they just made a photocopy of the order laid upon by Bart Jute and produced that. SD. Original is not signed. SD. Original do not refer to any annexure. But original, I'm sorry, copy order, I made a mistake.
Oh, whatever.
Copy original is
Order
not seen the
doesn't,
light of the day with now. Copy didn't put. So, if the annexure is on the order doesn't refer, or in the copy order, even they have produced, not referred to annexures. And by that order, what kind of link? Number two questions arise. First question is whether this order at all should be considered or it's admissible at all. Even if the next question, even if admissible, will this other order can be linked to it? Plot number 104. Here, Milord, I shall when come to the arguments, go to Lordship, the distance between the mill premises and this plot.
It's a different plot also found by the.
But apart from Milord, there are some.
So is different.
They divide
So is
by
different, it has to be distant.
public road. Then there's the children's park.
The
All this
Musa
on
itself
record.
is different. That hits at the root of the identity of the property.
Now, Milord, another question arises now, which we will find, may I address Lordship, whether this appeal file was maintainable. That. Now, Milord, what is the order of the BLR? Order of substance order is, in my submission and placed order was for replacement of a riot by an intermediary. BLR passed the order, not a basis of possession, etc., but he will the intermediary. Under section 6.3, an intermediary can be allowed to detain.
Yes. Yes.
So when the order is for replacement of a substitution of a riot by an intermediary, it comes expressly and clearly under this section B, 7.2b. Clearly expressly comes into that.
Which section?
Section 57b, capital B, subsection 2, no civil code, etc. B, a dispute involving determination of the question, either expressive or implication, whether a riot or an intermediary is or is not able to detain.
That relates to the bar of a civil code.
And it is right. Then subsection 3. Subsection 3. Civil code is excluded. So who can decide that?
Yes.
Any dispute referred to in clause, etc., may be decided by a revenue officer, not below rank of assistant settlement officer.
Yes.
His assistant settlement does it, especially empowered by the state, etc. So BLRO was assistant settlement officer empowered to decide that question. Very good. Then aggrieved. We shall agree subsection 4. Any person aggrieved by decision of the revenue officer made under subsection 3 may appeal to a prescribed authority not below the rank of settlement officer. The higher rank, it was assistant settlement officer, now settlement officer. And that was before the DSO, they put district settlement officer, which was done in this case. And this point.
And the order sheet of the SDO also mentions the appeal as under 57B4, top of it.
Yeah, Yes, yes. This
That
we
appears to be
filed
ordered
appeal,
the top of the caption of the
appeal
order.
wrongly mentioning section 54. And that was corrected and settled at 15B.
54 of the Land Reforms Act.
15B.
Must have mentioned as 54 of the Land
Treated as an appeal under section B. Without any objection, that part. Now I place this from this.
They may be in a catch-22 situation if they oppose the jurisdiction, because if they say that it was not an order passed under this provision, then section 47 does not clothe the bailiff with the power to pass that order. So then the parent order will be a nullity due to inherent lack of jurisdiction. We are putting this for the respondents to answer.
I'll consider
that may crop up.
jurisdiction take করে তাহলে 47 তো এমনিতেও ফিট হচ্ছে না তাহলে তো ন্যালিটি হয়ে যাচ্ছে এদিকটা না হলে
if
তো
well, this one didn't strike me.
এটা মানলেও
Right,
ব্যাকডে লড়বে
then
ওটাতেও একদম
they can rely on jurisdiction of the BLRO will depend on section 47, which they claim.
তো ফিট হচ্ছে
If
না
that is
So you are rather vesting clothing the BLRO with jurisdiction by preferring an appeal under 57 before.
either
Because
If
if
it
he
is,
did not, if the order was not under this provision, then section 47 does not empower it. So then the parent order would be a nullity.
That order, but we
That's why we said they might be in a catch-22 situation in challenging the maintainability of the appeal.
we have taken the point, Milord, but I would prefer to, I have submitted a lawsuit on the merits,
Yes.
on the merits, whether this order could be at all passed, assuming he had jurisdiction.
আমাদের ওই পয়েন্টে হারিয়ে
That's the point. That is it. It gradually, Milord, will appear something has been done, which had no jurisdiction. If record of rights are directed to be changed without going to question of possession. Judgment Gallot, I'll place one or two later. That is, possession is the most important part. And here, DAS or order is right. Is I cannot decide title, for the suit is pending. A suit is filed by them, but deciding title. So, they cannot, even apart from general law, judgment-made law, in the facts of our case, it is more so, because the title suit is pending before a civil court. That should be enough to take a jurisdiction of the BLRO. When a title suit is pending before civil court, why do you go into question of
But again,
title?
civil court does not have the power to do these things.
Let
Would
them
have been
win the
done by
suit. And then they'll get recovery possession also. Trial is also there.
সিভিল কোর্টে তো এই করার পাওয়ার নেই
হুম,
এটা তো
হুম,
কি বলছেন যাচ্ছে এর মধ্যে দিয়েই করতে হবে
Ki?
স্যার বলছে সিভিল
That
কোর্টে তো
one,
পাওয়ার
we shall, that is a matter of civil court. It may be, we shall fight out on merits. That you have no title, maybe. And maybe the additional ground. Normally the civil court will like to decide all points. They may decide on maintainability and also
As an
decide other.
ancillary release,
No,
civil court can direct the records to be
Right.
corrected if title is held in favor of somebody.
in some judgments, because they will say
The
somewhere that
forum to decide that.
first
The title is
thing the
dependent on
forum
this,
decides,
then
that's
reverse cannot be.
now
That's a
Milord,
typical
come to the final chapter now.
Yes.
From there, appeal was filed from this order of DSO to the tribunal by this one number 2, at is barred due to
ইন্টারপ্রেটিভ পয়েন্টে হারিয়েছে
and Milord, in filing appeal, they applied for also interim order. And Milord, I'll place only one part of interim order. Interim order was refused by the court. But point was, they took the ground that since the appeal is not maintainable without jurisdiction, because DSO had no jurisdiction, therefore he had no jurisdiction to pass the order, because he could not maintain the appeal from the order of BLR. That is the point taken. And that point was taken as the ground for say injunction, because DSO order is without jurisdiction void. Or decided by the tribunal, the then tribunal, judicial officer was different, but admin was same. Anyway, holding that, no, appeal is maintainable. from that, they have paper also read file করেছে তো, no? Now, may I come to that order first and then second order?
What is we are sitting over judgment
Lordship-
which order?
Hmm? Yes.
What is-
Final order, final order.
Okay, that
There I'm reading because, my lord, the second LRTT, second next judicial officer, one of his ground taken is that DSO had no jurisdiction.
so this order has been set aside by the tribunal against which you are preparing
The first tribunal order saying that appeal is maintainable, yes, SDO had jurisdiction, DSO, has been totally.
But Mr. Mitra, that was probably at the ad interim stage and that could be revisited at the final hearing stage of it.
That therefore question of res judicata will arise. I will show that. Now Supreme Court has given judgment also what they call
During the
expression
same-
use interlocutory res judicata.
interlocutory dispute, during the same proceeding it can.
That part from merit. Whether she would have at all gone into the question. That's why I'm placing that order of interim order. I wouldn't have. I'll place only that portion, one page only. This order, interim order application. Now, this order, please come to relevant part of the key of
Yeah.
a long order.
This was the ad interim order.
Interim order, that portion only,
Interim order.
where the question of maintainability arises. It's 12th of March 2024. 2024. And I'm trying to show you also only relevant portion.
29.
No, it's not true. 12th March 2024. না হাইকোর্ট পরে আসছে তো আগে ওখানে দেখিয়ে দাও হোল্ড করেছে কোনখানটা জায়গাটা দেখিয়ে দাও অন্য জাজমেন্ট now considering all judgments of side, kindly come to page 329. I'm at the midst of it. I'm showing it also.
Yes, yes.
Page 329 of the compilation. This is the the argument discussion starts much earlier. But come to the concluding part, the judgment was cited. So many judgments were cited. Then all the judgments were pronounced of different legal, factual, etc. As per the ground mentioned above, for these decisions are not applicable in the present case, as the provision for appeal under petition B, subsection 4, is squarely applicable against the order passed by the
You are
applicant.
reading which page?
Page 329 below,
29.
last paragraph.
Actually.
All judgments, etc. Last paragraph. All
Yes.
the judgments were pronounced not applicable. Above, for which the decisions are not all applicable in the case, as the provision for appeal under section 15B4 is squarely applicable against the order passed by the applicant under section 47 of WBA. Then can we continue? The applicant advances his argument on some matters touching the merits of this case, which cannot be considered at this stage. That is, therefore, decisions cited by the appellant touching the merits of the case will be considered at the time of final hearing of the original application. But as the point of maintainability is required to be addressed at this stage regarding jurisdiction of the appellate authority to take up any matter against the order of passed by the BLRO, the above matter has been taken up for consideration by dint of observation made in. As my lord said, if maintainability is raised, that will be decided first. And it was decided, finally decided. That's what I'm showing you also. Interlocutory judgment, the question of maintainability decided finally.
So the tribunal construed section 47 also to include a question as contemplated with section 57B2B. That
Yes, and from this,
if it's a dispute involving determination of such a question, whether someone is a riot or an intermediary, that may also crop up under section 47 and that is also amenable to appeal.
It's also
That was the premise. Because the tribunal says is maintainable against section 47 also,
That's all.
order also,
My lord.
provided that question, a dispute involving determination of such a question arises.
And on magistrate, is not a prime minister case is not for
Merits
injunction.
otherwise. Yes.
From this order, my lord, they file an writ petition
Writ petition.
before division bench. And the division bench did not did not consider and upheld this order. Division bench order, Lordship want to see, I can
Yes, yes.
place the order, which is, my lord, 17th May 2024.
Yes, we have it before us.
17 May,
Immediately after this.
page 45. 340 starts. Lordship will find in the before the division bench, no argument was made regarding jurisdiction, this maintainability. No argument was made. The argument is the thing made, and the division bench will this.
Now the writ petition has moved one generation up.
Yes, then now. Now it
Yes.
then after he comes final hearing,
Yes.
because of order. Then before the matter could be heard finally,
Yes.
after the interim application failed,
Yes.
they get interim order couldn't get, then state government filed an appeal from the very same order with a delay of more than 600 days.
After this order, they prefer
Yes,
the appeal.
after this interim order refused by the tribunal. And their ground for constitutional delay was that because interim order refused, we have advised to file the appeal. As a constitutional delay petition.
It was represented then.
It's
in
there,
their
I
appeal.
show you, Lord. And but from that, they
So the
also
learned
apply for
advocate has
interim
a-
order.
Learned advocate general has a legacy to uphold.
That was the ground convention of delay petition. And from that order, but the tribunal condoned the delay and allowed the appeal to be admitted.
Ultimately,
Yes, but did not. They made an application. The state government's appeal, constitutional delay, tribunal allowed.
that is pending at that stage.
No.
Dismiss it.
By the same judgment ultimately. That's my pointing out, my lord. There is not the interim order was not granted. From that order, my lord, they prefer an appeal. Writ petition. We also filed a writ petition before the High Court. High Court, let's say, the constitutional delay.
Why are there 3 writ petitions, 2, 3, and 4?
Then, my lord,
Before us, one state government's appeal, one respondent's appeal.
but 2 appeals. That's all.
2 to 4 দেখাচ্ছে board এ?
Huh?
Third appeal for mutation give effect to the
কোথায়?
এখানে
Oh, I'm sorry. The 3 appeals.
127
কোথায়?
127
Huh?
এখানে
কেন করেছে? কেন?
127 was filed by us for seeking the mutation. Since tribunal has passed this order to implement.
কিসের appeal হলো?
what করেছে
কেন?
তারপরে order to implementation
That was a consequential probably application for implementation of that, basically.
Right, that's right. Well, that will depend on this.
Yes, yes.
All depend on it. So only one judgment disposed of both appeals. Now, therefore, the Lordship will directed one set of paper book will be filed. Now, please now come to the the final chapter.
Yes.
What's that page? In a compilation, and compilation is not there.
The next one.
Compilation is down it.
Second volume of this bound volume.
এটা down it hangam sugar যেটা তো down কেন?
সেকেন্ড ভলিউম আছে
But
এটা compilation volume
final
sorry, compilation volume 2.
we can write as well, final chapter.
এটা compilation volume 2.
Yes.
আমাকে দাও সেটা তাহলে একটু দেখিনি।
The learned advocate generally is at a total loss. Because he served last night and poor Mr. Mitra is. Now you have taken the office, Mr. Mitra, you have
কোথায়
to
রে?
bear the burden also.
আমাকে যেটা দিয়ে সেটা দাও।
Who told you? Your own choice.
পেয়েছেন? আচ্ছা পেয়েছেন খুঁজে?
জোসেফ দিয়েছে
Has they got the judgment?
Now, yes. Oh, this is entirely comprised of that judgment.
No.
So Banerjee, you must have been arguing for one of
Fact recital is there in the beginning. Then
volume.
them. He was
yes,
instrumental.
and doctor, not funny.
It's a thought.
Yes, we have checked up.
Hmm? The convenience volume number 2. Patient,
We can remove the word convenience. We can- But definitely this helps. This compilation
That-
definitely helps. Undoubtedly.
But the basis of the order now comes to the first of all that replace the entire judgment.
82-page judgment.
If necessary, relevant part, argument part,
Yes,
not
yes.
argument part.
Yes.
Come on, get on.
Yes. Which
Similar values come to and আমার থেকে down.
that
আমি
cannot
আমার
be
থেকে
the one. That is thinner.
I mean, content regarding entertainment taken. All this taken.
41 থেকে
Page
page 41.
page 41 it will. Inner page 41.
Yes.
Inner page 41 too. Yes, decision page 40. Inner page 41.
Yes.
Decision. Upon consideration of pleadings,
Infinity by half still equals infinity.
it is all right. But this is up to page 40 you are skipping.
Thank you so much for that.
But then remaining another 40, what do you consider?
That is what I said, that infinity divided by 2 is infinity.
Upon consideration of pleading, etc., we appears the following point requires determination. Whether appeal number under section challenging order repeal was maintainable before the district settlement officer. And whether district held, yes. Whether district settlement officer, no, sorry, he was not maintainable. Answer was not maintainable. No, answer not maintainable. Whether district settlement officer authority to review, reconsider the order notification issued by government under section 3 of this. This is, I don't know how this point arises, right?
Yes, this is
The
proceeding.
point doesn't arise at all.
Correct.
How this, whether the order is review, order is not sitting in appeal, nobody is done arising. Whether order dated and passed in appeal number demands interference. But you what relief one entitled to this kind of issue? You what relief entitled?
Yes.
Passed by a civil officer,
Yes.
legal valid. Then this is important. Additional point. Whether the order passed by the BLRO, assistant officer, is legal and valid and tenable in the eye of law. So that is second point. My Lord said, even if that ignores, what about this?
Yes.
This is argument. What about this BLRO? This book of intervention, etc. Then, my Lord, start. We have gone through the note miscellaneous application, etc. Now. Taken up by council disposed to the application. That kindly come to about again facts are reiterated. Again, facts are reiterated while considering. Then, I have to wrote it down. Yes.
What did you state in the application to justify this finding at page 42, last paragraph?
That
Last paragraph says,
arguments are again noted.
we have gone
Next,
through
advocate has
meticulous-
pointed out.
You say something to urge the tribunal. The apparent that the application is an end result of uncanny apprehension that applicant them would distract the bench from the pleadings of the parties. And documents garnered on record on that. Very unfortunate. Whatever.
Again, arguments are repeated.
What did they say?
To show all the originals, that is the detention order, and the list of plots, details given, those which have been showing that certified copy by Barju.
So this is in respect of that.
Yes,
But you are-
all the originals, but they did not allow us to rely on that.
Original?
Yes,
কোথায় পাচ্ছে?
It's not spelled out in so
Original.
many words.
not in so many words,
Oh, no,
but that
no,
was the
not in so
reason.
many. It is
I
not.
was there. We all of us
Yeah.
were there.
Doesn't change the fact. Your appearance does not change the fact. What is produced a copy.
No, we agree with you.
Clearly copy. Oh, Mr. Thank you, Mr. Dos. We appreciate the weakness of your case. That you are, unless it is original, you have no case. Thank you. But you cannot, oral argument, you cannot change the fact. Right? That's all. Not, this page 46, Milord, last paragraph, the maintainability argument. 46, 47.
Yes.
Again, argument noted.
Yes, again argument, sir.
Noted, we argue, this is as you cannot go into this question. Noted, is that? Yes. Please,
The arguments are interspersed with the findings of the
what's
tribunal.
the
That's difficult.
finding that can you see now? It's section 57 B3, page 47, middle, referring to section B3 of the West Bengal Acquisition Act, and as submitted, section B3 pertains to dispute referred to in clause B of section 2, which can be decided by the revenue officer, and clause B relates to determination of question of exceeding. Next condition put for a learned advocate is proceeding under section 47 Act does not fall in the scope of dispute. Again, argument noted, argument noted.
53 থেকে আসছে ভাই।
Milord, kindly come to Milord, I'm told page 53.
Yes.
That's considered.
Let us consider now. 53 mark করা আছে দেখছি। হ্যাঁ, it has been কোথায় গেল?
No, in between.
Let us consider middle.
At page 51. At page 51 also. Oh no, sorry.
Page 53 Milord, repetition.
Yes.
Page 53 middle. Let us consider the rival contentions with reference to factual aspect and relevant legal provisions.
So 12 more pages saved.
Yes, no, it is undisputed. It is in compliance with the order of the district settlement officer and district land and land officer, the 24 organized by memo number dated 16/1/2004. SRO, BLRO initiated proceedings. Compliance with order. He is not independent man. And initiated proceeding is under section 47 West Bengal Act. And by an order dated, essential, again, repetition. It remains undisputed. A Rotterdam contents by be limited. Challenge the opposite order passed by the, again, but why this repeat again? Why keep on, I keep doing it. Authentic copy order of the High Court comes, the photocopy.
54 last paragraph.
Yes, we are looking at that.
54.
54 last paragraph speaks of section
Images
54.
on the authenticated copy of the record of appeal. এটা কি আছে? And initially appeal was filed on the second 54.
That conversion is also reopened.
That's relevant. It emerges from the authentic copy of the record that initially appeal was filed under section 54 and the same by virtue of order dated wrong. কত? 17 February 2022. What is the correct date? But I didn't appear in the matter.
We have taken note.
That when junior appeared. That order is there. District Officer BLRO was treated as an appeal under section 57B4 of the Act. In fact, there is no provision either in WBL Act 55 or WOC Act for such conversion. But this conversion done, order দেখিয়ে দাও, without any objection. কত? Page? Page number দাও, just go back to that VAT compilation, volume 1 of the compilation. এখানেই বলেছে? Ito.
Yes, doctrine of necessity and necessity knows.
Appeal and district officer, such convention of invoking doctrine of necessity. কোথায় পাচ্ছে এটা? দেখিয়ে দাও, ওটা দেখিয়ে ভাই। Necessity knows the law was moved, but because of obvious settled law, right to appeal is created by statute is not an inherent right, correct? Such conversion is made by district officer being unknown to law is not legally tenable. So a conversion allowed by his predecessor, the tribunal, and that conversion or change, as I make it, done without objection. Order dekhiye dao. And then he's sitting in appeal over it. 274.
Not his predecessor, the DLLR who made that conversion. He's saying. He says DSO. DSO was the DLLR. Yes. So DSO one notch lower.
274A, Milot kindly page 2 of the volume 1 of the compilation. Similar order. But the background I was not there. Mr. Dhar was there. No, তোমাকে বলতে বলছি।
No, you are there.
বলতে পারছি না।
Stops there.
Not there. And Mr. Somo plainly explain what happened. That applies for
Sir Achudin can also enlighten us on the intellectual side of this property.
Order act as well files, case put up admission hearing. Both the parties file hajira, that chole gelo. As long as league independence today matter is fixed for the admission. The appellant file an amended memo appeal with a correction of the filing section of the instant appeal.
Does not submit.
Learned advocate on behalf of the respondent number 2, that is Mr. Dhar's client, does not submit any objection regarding this. Hence, the prayer of the appellant is admitted. Appeal will be treated as an appeal under section 51B4, hence instead of 54. And we filed an application for that, and that was not objected. So, I am humble, so this is totally unethical for this bench of the tribunal to go into that question and say had no power, etc. It's a procedural correction. No. Yes, same another electricity. I am told there is another order of electricity, another matter. This is the conversion has been allowed. Then I ordered this there on the record. I'll just tell you also don't stop. Now the next comes the question, my lord, is consider middle section 47 of the Act, actually incorporated provision for modification of finally published record of rights for any dispute, for any district or part of district in respect of which notification of section 4 of the Act has been duly published, by eliminating therefrom all interest of the intermediaries which have vested in the state, showing therein all the tenants who hold the dignity. So, Mr. he notes for intermediaries. And Kashipota was a riot. His name was encouraged as riot. Intermediary was barred. They were intermediaries, and under section 6 claims to be the right of detention. He knows that. Then Rule 13(1)(a) of the West Bengal State Acquisition provides that modifications shall be made in finally published record of rights, sub-rule 3, extent 2, in accordance with the provision of the section 47 of the West Bengal State Acquisition Act and paragraph 7 of Schedule B of the West Bengal State Acquisition Act. And in further such rule, it is stated that in doing so, Revenue Authority shall take into consideration all facts, including any statement as may be required for such elimination, etc. And so it is just a corollary proceedings after giving effect to vesting under Section 4 and West Bengal Acquisition and in finally published record of rights. West Bengal Officers Acquisition Act contains no provision for appeal against Order 47 and it was challenged in appeal under 47B. Now, my lord, then may I stop here and show you, lordship, how wrong it is. How wrong it is. Section 47 say as soon as possible, after notification, after issued, you may correct on how.
Eliminating the
Yes.
persons who are-
Immediately.
whose rights are vested.
Yes.
Basically, it's eliminating the persons whose right has
I
vested.
know. I know.
Tribunal is
And-
correct in a sense that in saying that it's to give effect to the vesting under sections 4, 5, etc. That's true. Principally, that's true.
So, my lord, this is a and what he can do under 47, eliminate the interest of intermediaries, not interest of liars. He could have eliminated the interest of Barjut as an intermediary if he wanted to. But only intermediary interest is gone. So, scope section is clear. The act is Acquisition Act for removing the interest of intermediaries and make the occupants the decedents. So intermediaries, that was the object of the State Acquisition Act. So if there is any mistake any intermediary is left out, then that will be corrected as soon as possible. As not immediately after, not as soon. So that is clearly, Miller 47 do not apply, had no jurisdiction. Then after that, Miller 57B4 is considering. Provides that person agree by decision of revenue officer, next paragraph, may appeal to, etc. Now, Section 15B3 provides that any dispute upon clause B, etc., may be decided by revenue officer, not below rank of it. It provides section is quoted. Then, last paragraph, conclusion is it emerges from Section B3 Act and the clause, Section B3B, which relates to alteration of entry in record of rights, finally published, revised, etc., under particular chapter 5, has been kept out. He said, kept out of the jurisdiction of the assistant settlement officer. Related to alteration of entry of right, finally published, revised, etc., and modified under provision of chapter 5, has been kept out in deciding edition under section 553. Section 47 comes under chapter 5 of the said act. Section 47, and so the interference which comes out, any area of order modification, and published, etc. Miller did it. Then see the argument and order. Now, in notes.
It is with res judicata.
But I think get it that it is left out, chapter 5 left out. Possible. Section chapter 5 left out. Now, next paragraph, our argument that can order and objection has been passed in respect of dispute involving determination of question as to whether a riot or intermediary. This argument noted. Since SRO, etc., Barakpur has decided the controversy as to whether finally published other record in subject has been foundation or not. He has not decided finally published whether finally published is what in respect subject plot has been found as any foundation or not. That is not the ground.
Ultimately,
Section 47.
Ultimately, decides that it was a decision on a question of law, pure question of law.
Section 47 is not the ground foundation or not. Section 47, any intermediate interest left out.
Yes, yes.
And that is, and it goes subject.
And he goes on to reverse the finding of his predecessor in office by saying that this is a pure question of law, therefore res judicata would not apply.
Yes.
That's basically what he has said.
Then Millard is appealability point, while dismissing MA, etc., was maintainable. Already pointed out that an order of modification of finally public record of rights, section 47, under section 47, it only pointed out an order of modification of finally public record of rights, record right published in 1955, and order is passed in 2008 and 2019.
Yes.
Immediately thereafter. This is Gajwari. Then now the question crops up whether a judgment of res judicata constructive or res judicata. Then similar.
And come to the end of page 58 where it says pure question of law.
Yes.
And page 59,
please.
Going from the wisdom, he says that.
Now,
no.
So in point number 2.
Yes.
Page 60.
Yes, we are there.
Because it's in that. That is another part. 60, whether order notification has an authority review, could reconsider an issue by the state government. He has not review. What? Nobody has made review.
What was the issue? We'll just look
They
at
say there is no order admissible. We can look into that. Court cannot look into this order, the document as an order. Page 60.
Yes.
But they totally, I'm not totally misplaced.
Number 2, point number
page 60, point number 2 is totally misplaced.
The DSO had authority to review.
Whether the district settlement officer has authority to review or reconsider an order. He has not done so. Yes, the order has not been produced before me. In spite of opportunity given. So I cannot take note of that. That's what he has said.
This issue itself
proceeds
on the premise that there was a valid order.
Right.
Whereas you had disputed that the validity of that order itself.
We have said that you cannot take note of that. Order is not there. Original is not there, only copy order. And that was without annexure. This is totally misguided himself. And goes on again 57B3 again considered.
Yes.
Keep But third point issue.
Yes. You see 3, yes. That's the general issue.
Point 63 whether order dated 22 in appeal, etc., demands interference.
Issue.
These two what relief, if any. A new point, now point number 3 is taken up consider. Needless to mention, point interlinked with the point number 1 and 3, interlinked with point number 1 and 2. These points can only be decided with reference to our discussion on those 2 points. At the concluding part of discussion, point number 1, it has been held. Appeal number 2-4, section bureau, telling order, etc., was not maintainable before the decision officer. Very good. Discussion point number 2, it has been ended. Observation, decision officer has no authority to review, yes, or reconsider order issued by. If any order, if any pass, then he cannot review.
Yes.
Question is missing the basic first point. Order, if any, passed. The order passed, then we cannot review. What is this misplacing the thing? I mean, that is answered, observation, check, etc. Totally, Millard is avoiding the main point that review of an order, but he doesn't note or consider whether order is there at all. He's considering order copy order.
That is what you say. He proceeds on the premise that there's a valid order, and then the issue itself is framed like that.
Even if the correct original order is produced or certified copy, then this question will arise. And certainly we will not ask for a review of the order. Then question will be whether this order embraces plot number 104.
Yes.
Because the order is without any annex, without any list land schedule. That is the two questions only arise.
So you say that the DSO did not review any order.
No,
There was
no,
no order at all in the first place pertaining to
Because there
this
is
land,
no such order.
this plot.
And the order doesn't include, we cannot link, because order has without any annexure, without any list of land schedule. This is a simple point. I mean, it is avoiding the main issue. The records are here, আছে record আছে তো এখানে, record আছে তো, এসেছে, record এসেছে কি? Record এসেছে ট্রাইব্যুনালের? আছে? Kindly show, my lord, the order which was produced before the court as 60 order. Because learned friend Mr. Dhar says original was produced. See what was produced.
All of those are in the paper books.
Yes,
did not see the
copy,
records.
which have annexed.
If Mrs. Hort says so that it was a part of the record, then we look into the records. Otherwise, we need not look into the
Then
He
this
said he
is different.
tendered those. He did not say that it was a part of it.
And it's SD. SD.
Whatever is there in the paper book was a part of the record.
Certified copy of the state affidavit.
I was the certificate, the order was annexed by the state government, and having opposition certified copy, I'm showing you what was annexed. This is the order.
Hey,
See,
লাগবে না।
okay. See, we know what was annexed.
Oh,
That order which I've shown you, Lordship.
there's a signature of the assistant secretary.
SD and no mention of any annexure, enclosure.
This is the lower court record.
This was what was annexed or disclosed by the
Assistant secretary is apparently signing it. This says that the assistant secretary is signing it.
order to deputy secretary মেমোটাকে সাইন করেছে ডেপুটি সেক্রেটারি তো বলছে অর্ডারটা দিয়েছে সেটা এসডি হয়ে
SD.
Yes.
This is the lower court.
Yes, ICC is really forwarding the order, right? Forward. Very well. Yes.
Now, on this may come say to the when an order, it is a public record, can be relied upon by any court. Okay, 15 minutes. তোমার সার্টিফাইড করবে এখন বলছে তোমার অরিজিনাল আনেক্স করেছিল তো তাই দেখাচ্ছি। Now, when an order of public order and an official order can be at all be looked into by a court, any tribunal. Section, can you take the Evidence Act? If you go for Evidence Act. And there comes straight to a judgment also on this point. Evidence or no Evidence Act.
Primary evidence, secondary evidence,
Now
certified
we're
copy.
changing to something else. Is MPLJ দাও, মধ্যপ্রদেশ ল জার্নাল দাও, 2008 এভিডেন্স সেকশন দেখো, সেকশন 76 কপি দিয়ে সুযোগ সাহেবকে।
এভিডেন্স অ্যাক্ট নেই কেন? ছিল তো।
দাও, কপি আছে এভিডেন্স অ্যাক্টের? আমার মনে খুঁজে পেতেই মুশকিল হয়।
Yes, we have both of them.
I mean, after this, government had the second opportunity of producing the order when they made an appeal.
Yes.
What they did, they simply copied this order, this very same order, and annexed it. State government was a party. They did not produce the order or any certify, could not even certify order. What is this?
Section 63 says certified copies.
Yes.
Standard evidence.
No certificate copy.
This is not a certificate
No.
copy. Yes.
Bath company in the copy said certified copy. But
Yes. There was a certified copy, but certified by someone.
See, there are two sections are very clear. Evidence Act says a document is produced by best is primary evidence, namely produce the original. Secondary evidence admissible when. In case of orders of government authorities, public records,
Yes.
an exception is made that certified copy is admissible.
Yes.
Section 76, 77. Kotha, evidence act kotha. এটা কি দেখাচ্ছ এভিডেন্স অ্যাক্ট তো দাও 76 দেখো 76 তো ঠিক বলছি তো মন থেকে বলছি similar public section 74.
Yes.
I'm admitting it is a order is a public document, government order, some section 6, public document. If then mirror how they prove. Section 76. Every public officer having custody, etc., public document which any person has a right to inspect shall give that person on demand a copy of it on payment of legal fees, together with certificate written at the foot of such copy that it is a true copy of such document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer, which is name, official title, and shall be sealed whenever such officer is authenticated by elected. Three things they required: certificate copy. Firstly, name will be mentioned. He will, with the name and official title, what is it, deputy or some officer, and have to bear the seal of the government. And that is authorized by law, makes such thing. And second, makes it clear, such certificate copies may be produced in proof of contents of the public documents or parts of public documents which may be purport to. That it is admittedly not a certified copy of the order. Then what's in law? What's the status of this? Just take a look to find a few judgment.
This read with section 63 and section 65 also. 65.
There's one judgment of Madhya Pradesh relying on Supreme Court judgment. 79 was that? Oh. 70, management correct. 77, dekalum to. 79.
Yes, 76, 77.
79 also, second thing.
Yes.
Then certificate copies, presumption of genuineness is there.
Other provisions also, so yes.
Other copy made by somebody is not.
Section 63(1) says certified copies given under provisions shall include secondary evidence. 65 E says when original is a public document within the meaning of section 74, it can be produced. 74
And
refers to official documents. And that 63, 65.
Kindly Miller, one thing, who certified copies, a document which any person right to inspect. I've seen that. Every public officer having a custody public document, which any person has a right to inspect. But that document must physically exist. And to that have a right to inspection.
Yes.
Any public document, any member of the public can take inspection. And this document not there. So if that is liable to inspection, that is inspection can be given, then question certificate copy arises. It clearly postulates.
Certified copy presupposes there is an original in existence.
Must be original is there.
Only on the strength of that can a certified copy. Otherwise, I cannot imagine a certified copy. I cannot imaginary. There cannot be an imaginary certificate.
I must have an original of which I have a right of inspection. Any member of public a right of inspection. So there must be an. They have not given inspection of any document, original document. How certificate copy can at all given in this? It's not given. So we have two things. there must be original document which is open to inspection by member of the public. First thing. And second, that document can be certified by a named officer giving his designation, seal of the government. Then it is on which it is admissible regarding contents.
Yes.
79.
Only then 77 comes in. And 79.
And 79.
77 is very important.
Right. This
79 is only on genuineness. 77 says it can be proved. It can produce in proof of the content.
Take it. I say, put it in 77.
Yes, yes, we have seen this.
Yes, put it. Now, my lord, there is judgment to the effect, judgment of court, particularly when the court has given opportunity to produce the original and they have failed to produce, then no presumption can be drawn about correctness. Presumption, that I give you a case, but a Supreme Court case where certified copy was produced. The Supreme Court said this certified copy is not produced in accordance with the provisions. Therefore, this is no certified copy at all. And therefore, no presumption. I side note about time. 2008, Volume 2, MP Law Journal, 180. This is this considered 1959 Supreme Court, the parent case on this. Parent case. Russell Calisi, paragraph 15. Now, what could paragraph 15. 15. 15 now, 16, 15, 16 onwards. Down what about it not Supreme Court judgment everything. What a key it. That's what they are. No. 15, second 15. Under that MP Act, Land Revenue Code, it's also a record of right matter. That's why I'm citing in note. Under Section 107 MP Land Revenue Code, as a revenue law prevailing in the year, there is a presumptive value of correctness of revenue record. Question that hinges is now that when such presumption can be drawn. In the present case, document exhibit P1, P3 are not the certified copies. And if that would be the position, it should have been proved like other documents. Who has signed these documents? There is nothing on record and no evidence in that regard has been placed by the plaintiff. Section 76, Evidence Act, speaks about certified copies of public documents. Procedure, how they are given, Section 77 of the Act, says the mere production certified copies of the public document is the proof of is not would be presumption. And then under Section 79, there would be a presumption as to genuineness of a certified copy, genuineness, if the certified copy public document is produced before any court under Section 77 of the same Act.
The crux of the ratio is in para 16. The middle of that, the certified copy of a para 16 middle, certified copy of a public document in the custody of a public officer need not be put. In order to attract Section 76, it should be borne out that public officer was having the custody of public document, which any person had right to inspect. And it's premised on this.
Inspection is very important part of it. Then 17 Supreme Court judgment is noted, 59 Supreme Court 960.
Yes.
As categorically held. So, then conclusion 18, upon going through the revenue record of the settlement year, etc., which is certified copy of D3, it is gathered that only name of the settlement is about to get. Then after saying paragraph 20 concept for the reasons set above, since the alleged revenue record P1, P3 are not at all proved, as they are not certified copies, no presumption of correctness can be raised.
They have again refused. Mr. Sharma?
No.
Okay, thank God. So we'll come back after this.
This matter will continue for the day.
Are we arguing the matter?
Only two matters left after.
Only thing
May
is,
or may not continue. Sir. We are not sure. We have come, you will also have to. Our hopes are dashed, so your hope should also be dashed. Hopes are dashed that we would be rising early, so your hope should also be dashed that you will be released. We may, all on a sudden, we may find out that something is not there and we may drop this matter and take up the next.
বলো আমার
We may do that. And we'll do that with certain amount of sadism.
বলো কন্টিনিউ কন্টিনিউ
We'll come back up.
my lord, only thing is, বলো।
Yes.
No, I was praying, my lord, if I can get, my lord, an opportunity on some other day, my lord.
In any event, maybe you will be getting that opportunity.
I
and
do
some
not
other-
know. I do not know.
Yes, yes, sir. No difficulty.
সুপ্রিম কোর্ট
You'll have to renew that prayer at the end of Mr. Mitra's submission. And that is the only right.
No, no, I am not leaving.
No, no, we understand. Yes, obviously. You say, made that clear at the outset.
and the suit government also party in the suit
Yes, yes.
যত ওরা চাইছে না
You have what? We also have, but we are sitting.
I will come back with decide তোমাকে দরকার আমাকে
Before taking up this matter, the next one is my matter. I have an appointment with the doctor at 3 p.m. So, Lordship, kindly take it up this.
Just inform your other side.
I have already informed.
3, 5.
5.
5 target agreement.
Yes.
Yes, wait.
I cited judgment that a copy order is not admissible. And I showed from the order of LRTT
Yes.
that the order is based on the copy order. That, just I give you the page numbers. These are page number page 65.
65.
Page number page 65. Down. Yes. Second paragraph.
You should change the person from where you have.
In that page 65.
Not
in that volume 2, Miller order judgment in volume 2
person
of the
from
government.
this compel this.
This is
Binding was.
Yes. এত বেশি মোটা হয়ে গেছে।
In our case, you can do that if you feel, it's easier to handle also.
Photocopy.
You can do that. In our code, we are just telling you openly. Not only this, I mean, even this citations also you can do that. We don't have any issues. Rather, it would be easier.
69
দেখো দেখি তো একবার দেখি তো got the judgment no order
69
compilation
second that order of
the
final
judgment,
which is impugned 69 ও তুমি বসো লিখি নি হ্যাঁ
65 first paragraph.
Yes, second paragraph. 65, in at 65, second paragraph.
And also the second paragraph, it says a copy of
photocopy of the order dated April 7, 64 of Deputy Secretary.
Everything was photocopy.
Photocopy. Then, this is similar. Then kindly come to page 69.
Next.
Next, learned advocate contended appears from the replies to RTI as made by the state government. There is no record of the alleged detention. This is the last but one paragraph.
This is advocate for whom?
Learned advocate, no state government. That application made by the
for you. Your
Amra, we applied for.
Yes.
And that is retention order reply is also part of this record. And has been recorded in order dated
the order itself
under challenge.
That was the ground of the order imposed.
Yes. Ground is mentioned.
One of the grounds.
Page 74, thereafter, Milord.
Yes, yes, repeatedly. There is no doubt that photocopy was produced.
Last paragraph, Milord. Last
line.
No, but Jute, they have claimed that state government by an order dated 7th April 64 allow Lansdowne Jute to retain action as a nil. A photocopy of the order dated 7/4 Deputy Secretary has signed of the deputy, not signed by, and etc. was forwarded to is Annexure C discloses the copy of the order number dated in copy of the order. All throughout copy. Now, Milord, please see the reply, this RTI reply is at page 285 of the compilation. Page 285. With due respect, I being sitting, etc. Then A, whether dark number we are writing, Akhil Bonu Singh, his name, whether dark number such and such, 104, under any scheme of provision, B is important. Whether any detention order in section 6.3 has been passed in respect of say dark number 104. Court, fees, etc. Can the reply is given? Next page is a reply. Next page. in exercise of the provisions of the 54 RTA Act, undersigned is to forward or copy of the application answer.
This is the forwarding of that.
To the is required informant.
No, no, it's nowhere
But
in the next few pages.
পরেরটা দেখাও, পরের পেজটাই দেখাও না আগে। দেখাও না, পেজটা দেখি, আনসারটা খালি দেখিয়ে দাও। কোথায়?
Is not available.
Page 289 Miller's answer ultimately. 289. Information Right to Information Act. Deputy Secretary, undersigned is directed to refer to the above subject and send herewith the application of Akhil Mond, etc. for providing necessary information. Under said rule, as the required information is not available at this department.
No, to the ADM and DLLR it was sent. ADM DLLR
Ninth March order. আবার একটা আরো
দাও না, এগুলো দাও।
এখন ফরওয়ার্ড করে দিই।
Now, page 293 refers to 293 RTI petition, Akhil Bandhu, etc. Allowing inquisitor transfer valid as the matter. You requested reply to the applicant directly, along with the copy to the undersigned. That's what you need to.
Order was issued by such and such. This is not preserved in the office of the undersigned. Page 293B says that. Not preserved in the office of the undersigned. 293B, it states that it's not preserved in the office.
এটা অন্য অর্ডারটা এটা 29061 এ অর্ডার প্লিজ ফার্নিশ a copy of the said reference
1812 1812
yes
ওটা ছেড়ে দিন ওটা ছেড়ে দিন
করে দেখো ওটা নিয়ে দেখো order গুলো দেখো এই ইন্ডিয়ান ল্যান্ড
289 and 293B. Not available, not preserved in the office.
Not available.
Not preserved in the office also.
Yes.
Yes.
This point was taken.
Yes, yes.
And we have seen the answer, page 76 of the order of RTI, impugned order. He notes that. Second paragraph, page 76. He notes it was not available. And his reply is given. In response to the application, etc., RTI Act, required information, reply dated that the required information not available with that particular department, specific wordings used as the required information is not available at this department.
Then it proceeds to clarify that
reply as
does not mean that
does not mean that
no
notification of retention order has no existence. Yes. The reply clarifies the document was not available at the given time. At the same time, such reply highlights utter bureaucratic apathy and nonchalance of the departmental concern in the matter of maintenance of old office records. A copy of the retention order was communicated to the applicant twice in 1993. The said order was circulated widely. Why I don't know why widely. So in existence should not be questioned.
Why does he get it?
On the mere ground.
Widely and all this.
This is the reasoning. This is the reasoning. Complete ignoring law. And it's a bit artificial answer, below. This answer not artificial, totally artificial answer. The state government has not denied that's the ground. So regarding existence order, this is all he has said.
Yes.
And in total error of law, the face of it. That is the only basis. Issue number 3, also remember, it took there's the issue number 3, saying that whether the order of BLRO is correct or not.
No, you are citing judgments.
Yes, yes. Issue number 3, answer is given. Is answered. Is given the answer, show to your the answer given to issue number 3. The what could do? Yes. Let's please come to at page A4. Issue number is very succinctly, precisely answered, page 63. Very precise, succinct answer. Issue number 3,
Wrapped up.
whether order under possible
Wraps up
demand
the
interference. That BL order.
Wraps up
Issue
on the
number
basis of discussion on issue 2.
taken up for consideration, mentioned that point interlink issue number 1 and 2. This one is declared. We decide to do different as the concluding part of discussion.
Yes, we saw that.
Yes. No other further is given. No further reason. That is all. And then, my lord, he has not dealt with the reasoning given by the DSO, which was under appeal. That he has very smartly bypassed by saying.
He says also that I have not, it's not there, the origin is not there, but he attributes it to bureaucratic apathy and says that that does not necessarily mean that it is not there.
And reasons given by DSO has not been dealt with. He has about by saying order is bad. Order is bad. Therefore, he has not dealt with the reasons given, which can be adopted as part of our argument. And we did adopt. That what answer is given to that? So, my lord, this is a judgment. Now, my lord, I remain for me to cite one or two authorities, my lord. That because the reasoning is title. He has decided the matter on the basis of title and not the possession part. He has nowhere held that this property in possession of the proposed applicant for in the name of Barjut in the other settlement. Yes. Another. Now, for basis of the order, has it ever held? So, this order is totally devoid of the main thing, without holding that the party applicant is in possession, without considering that, how can he say? And he notes that prayer is made for recovery.
Yes.
Now, please, Vinod, concluding part.
DSO direct করেছিল এইটাকে দেওয়ার জন্য 60 অর্ডারটাকে প্রডিউস করতে গভর্নমেন্ট ইজ ডাইরেক্টেড টু প্রডিউস অরিজিনাল কপি অফ দ্য ডিটেনশন অর্ডার অফ 63 এটা ডিরেকশন ছিল ডিএসও
ছিল প্রডিউস করেনি তো রেকর্ড করা আছে
অর্ডারও আছে স্পেসিফিক অর্ডার
আচ্ছা রেকর্ড আমি পেজ 79 is based on the detention order. Second, the first order is that state government has not disputed. That is, now in adversary proceeding, state government is abstraction. Some officers who are representing, they have not disputed. Very good. They are siding with them. I should put him copy of the whole thing. 79. Second situation is when there was retention order, quantum of land permitted to retain belongs to the state, but possession remains with the Lansdowne Jute Company Limited. Needless to say, very existence of applicant company suggests that there was order of detention. How? This is all that. Need to say the very existence of applicant company, existence of the Jute suggests that there is order of detention. This is logic.
Because there are very few jute companies remaining anymore. That's probably that impressive.
Then Miller relies on one document, another deed of conveyance dated 8/8/1904. This was not produced before the BLRO or even before the DSO. It was this is a quotation. DSF. But deed of conveyance 1904. They by this deed of conveyance, this Barjut is supposed to have purchased.
So he considers a deed of conveyance title, as you say.
In foundation, president, you know. Is it now deciding title? Now see the fellows, I deed of conveyance, I sole lordship. doesn't relate to. Anyway, deed of consummation purchase burden jude. So what burden jude became when the estate acquisition came into force? 1955.
Actually, Lansdowne purchase, burden due to what is managing agent.
Sorry, Lansdowne name was changed. Name was changed.
Oh,
It was the previous name of that. So when they purchased and became the owner, what happened on the when 1955 Act came into operation? All the intermediate interest goes. So ownership, etc., all cancelled.
Title deed was produced.
What's the relevance of this conveyance?
Based in the state.
The titles did not survive after 1955. So, and the arrest is made after 1955. This is the answer given. Then he cancelled order portion, etc. Now there's a few judgments on the right. Please pardon me. I'm citing judgment on the question.
Yes.
Whether possession can be gone, title can be gone into. Must be known to also. Just I'll measure. To 2021 SCC online, page 802, paragraph 5 to 9. Lots of judgment of our High Court. I am just Supreme Court judgment citing.
SCC online.
SCC online,
Copy will not
page 802.
Supreme
Page 802. Supreme Court.
In
Supreme Court. Page paragraph 5 to 9. These are dots. Then on the same point, process. I shall repeat 1997 7 SCC 137. Paragraph 21. 1997 7 SCC 137, paragraph 21. Dekhi to. Copy down, is it? No, copy.
Judgment. You are relying on Jitendra Singh or Balwant Singh?
Both.
Both, that's it.
Paragraph 5 to 9.
5 to 9 of which?
Of the SCC online. 2021. একটা দুটো দিও না একটা করে দাও আমার ভুল হচ্ছে
you are entirely responsible, sir.
I mean how to finish, that's why.
Thank you for that. No. 5 is also relevant. Para 5 is also relevant. 5 to 9 is 2021.
কোনটা?
2021.
Paragraph 6.
Maybe of relevance. We don't know.
Paragraph 6.
Don't know him personally, but
Paragraph
maybe relevant.
After you heard the counsel, then.
Paragraph 5 is the 8. So maybe relevant in certain cases that becomes relevant.
6. It is not in dispute that the dispute is with respect to mutation entry in the revenue records. The petitioner herein submitted an application to mutate his name on the basis of an alleged will. It is as such. From the record, it emerges that the application before the Nayab Tahsildar was made on some date before the death of Srimati HON'BLE. It cannot be disputed that right on the basis of will can be claimed only after the death of the executor of the will.
There are 7 and 8 Mr. Mitra, probably
7.
Yes.
7 is more to the point.
It's a mutation.
7,
not
8,
title and
both. A lot of judgments have been noted. Paragraph 8.
Yes, nor has it any presumptive value on title.
It is not count. Now,
this is the other way around, Mr. Mitra. This says that mutation does not validate title, shows title or extinguishes title. But your case is otherwise. The contrary to this. That by title deeds, rely on title deeds, you cannot decide mutation. That has not been held. It's a contrary proposition here.
Because mutation record do not prove title.
No,
that's why
not this case. But here, your contention is that the tribunal relied on title deed to come to a conclusion regarding recording.
Yes.
So title deed may be a valid consideration for recording.
Yeah, but the possession part he has not considered. When admittedly possession is now with ours.
But this judgment is not not for that. I mean,
admitted possession with us.
Mutation does not create title. But here it is nobody's case that mutation created title.
And the occasional consider effect mutation is that held that mutation property in revenue record neither creates nor extinguishes title to the property, nor has it any presumptive value
No, it
on
does not,
title.
does not.
Such entries are relevant only for the purpose of collecting land revenue. Similar view has been expressed. So, when this irrelevant matter regarding title in irrelevant matter is being considered, that's what DS also had said. Now, let I give you a lot of 1997 7SC is quoted in the judgment here. But which court we cannot tell.
But these judgments don't help you, Mr. Mitra. These say mutation does not have the effect of creating or extinguishing title.
Right.
It's the converse argument you are making. That on relying on the title deed, the tribunal could not held that it should have been made.
I correct. That I have
So
to
that's why-
satisfy lordship that titles are not relevant in an for mutation
Yes.
of the record of rights. That we have to cite. That satisfy lordship.
For mutating a property title, it can be cited. For mutating a property title, it may be relevant. May be relevant.
Maybe.
But in this case, you have a different.
Here, it says that title report is concerned, it can only be decided by competent civil court. Paragraph 8, lots of in that. Civil court. Or the revenue officer or the cannot decide.
Here the question is, Mr. Mitra, whether the tribunal was justified in validating, saying that yes, his name was correctly recorded or should be recorded on the basis of a title deed. Here, title was not decided by the tribunal. Tribunal says there is a title deed in its favor. Therefore, rather in a sense that mutation should be granted to him. Here, your argument is on law that 1904 deed is not relevant because after advent of these 1953 and 1955 statutes, land statutes, that has merged, vested in the state.
Yes.
So that title deed is not relevant for mutation. But otherwise, Mr. Mitra,
Whether
title
it
deed
can
is
be
definitely relevant for mutation.
They are cited on that, whether it is relevant. And not may I cite one judgment of Supreme Court. I'm now going slow. 2000, Volume 1, Supreme Court cases, 518. The our computer down. This judgment, Milord, may assist your lordship.
Yes.
That only possession is relevant.
Yes.
Yes, judgment diyeto. এটা আমার কবে দিলে হ্যাঁ May I read this judgment?
We want the bag out of the cat.
Yes, sir. Oh, এটা আমার বই এটা আমার বই ঠিক
The size of that will determine
I
how
have
long
got
we'll
40
hear.
book. Can you take photocopy of this? এটা দিয়ে দাও একটা কপি আমারটা নাও আর একটা কপি দর্শককে দাও হ্যাঁ
Can give him an indication as to what is the next judgment you are going to cite so that they can.
Similar short judgment. So may I read, Milord?
Yes.
92,000 Volume 1 SCC, page A518. 2000 Volume 1. 518. Justice, appellant before us made a claim for registration of occupancy right under Section 45 of Karnataka Land Act. Another, before the land revolution proceeding initiated under 48 of the Act, the tribunal by an order dated upheld the claim made by the appellant. Appellants and the respondent laid evidence. Tribunal noticed that the mother of the appellant stated that land in dispute was being cultivated by her husband. Malakupal said 31 years, etc. Respondent deposed that he has purchased the property in dispute for a consideration of 4,000. And he has been in possession of the land in question and has paid the land revenue. Tribunal, in order to ascertain as to who was in possession on the date on which Act came into force, that made a spot inquiry, as was done in our case also. It was found that the land was being cultivated and growing chili, etc. They also found the property in dispute was being cultivated by the appellants, and they have actually been in possession. A possession. Tribunal notice that receipt or dated had been issued by the owner of the land and co-rulers, etc. Now, my lord, the next paragraph, paragraph 2. The name, I can read that.
You can come to
entry
para 4, Mr. Mithra.
4.
And we have read 4 also.
Appears
May not
would
come
not have
there.
placed any reliance on the subsequent revenue record in
This is the proposition.
constructed building on the as warehouse concept. Matter of spot inquiry has shown that. Just therefore, a question of occupancy right is concerned. Title deed is not reserved. Title of the property is not reserved. This is on view of that. I mean,
Found that land was in their possession in the face of the finding of fact, appellate authority could not raise a presumption under that act that the entries were correct. When a finding of fact has been recorded, appellant has been in possession, startling to hold that respondent was himself in possession.
Yes.
Cultivating the land. So therefore, if there is proof of possession, records of rights have to reflect that. Yes, we take this one.
Same thing, Milord, has been said by judgment.
Did not cite all the judgments, sir. It's the same
That is
proposition.
settled. Now, Milord, regarding this interlocutory res judicata, there has been some judgment recently, and the physiology of interlocutory res judicata has been adopted, has been created rather. And 2025 SCC online SC 1218. It takes note of earlier judgments. Yes. Paragraph, kindly come to paragraph 22. Phase 4, phase 3 of 22.
Paragraph, sorry?
22. 22. Last paragraph. Appellant challenged the order of the trial court before the High Court. However, same came to be dismissed by its impugned order, that is at 21. High Court observed that the impleadment of the appellant was valid and his IA seeking deletion from the array of parties was barred by res judicata. High Court also observed that the claim of the appellant for independent possession was also rightly rejected by the trial court. The relevant observations made by the High Court are recorded below. Undisputed fact reveals petition, argument, order, etc. were implemented after inquiry. Then submission on behalf of the appellant, I am omitting. Then please come to conclusion, paragraph 34. Then submission appellant and respondent is noted. Then please come to paragraph 34. Learned counsel referred to the finding of the High Court in the impugned order, wherein challenge by the appellant to the dismissal, etc., interlocutory application, seeking deletion of the appellant from the party was rejected. He argued that the key finding of the High Court is that the impleadment under Order 1, Rule 10(2) of CPC had already attained finality, and that the belated attempt by the appellant to question the same was barred by res judicata. This is the contention raised. Now see the answer, my lord, how they're answering this point. Paragraph 42. And issues for consideration. Then Miller, then this is factual case, answer. Then analysis. Suit in the name of wrong plaintiff is given 42A, where the High Court committed error rejecting the original petition filed on the ground the IA for deletion of the name of the appellant was barred by res judicata. This is the ground. Now, my lord, kindly come to the 53 now. The High Court, in its impugned order, held that the application of the appellant under Order 1, Rule 10 to be barred by res judicata, and thus not maintainable on that ground. We find no infirmity in the said observation made by the High Court. Mad by the High Court, I guess.
Maybe.
Justifiably. This court is Manus 2051 SC 1787. Observe the principle res judicata apply not only to two different proceedings, but also to different stages of the same proceeding as well. This is the point.
Yes.
Relevant observation are reported reproduced below. It is now well settled that principle res judicata apply in different stages of the same proceeding. See, therefore 960 SC, 1881 is given. Then 1976 4 SCC. It is well settled that principle res judicata can be invoked not only in separate subsequent proceedings, but also get attracted in subsequent stage of the same proceeding. Once an order made in the course of proceeding become final, it would be binding on the subsequent stages of same proceeding. Then again, 1999 5 SCC, one public policy is that decisions pronounced by the court should be final unless they are modified or reversed. This normal after that, thus paragraph 54 is the summary. Thus, as the dictum of law is as extracted above indicates that the only manner in which decision arrived at by a court of competent jurisdiction can be interfered with by modification or reversal by appellate jurisdiction. In the present case, the order of impleadment of the appellant as a legal error was made by the trial court after inquiry under Order 22, as also observed by the trial court in its order rejecting the application of approval. Evidently, neither any objection was raised by the appellant before the trial court, nor any revision was preferred subsequently against the said order. Thus, it could be said that the issue as regards impleadment of the appellant as a legal heir of the original defendant had attained finality between the parties, and thus subsequent application order Rule 10 seeking to get the name deleted from the array is said to be barred by res judicata. Undoubtedly, the expression at any stage of the proceeding using Order 1 Rule 10 allows the court exercises power at any stage. However, the same cannot be construed to mean that defendant can keep re-agitating the same objection at different stages of the same proceeding when the issue has been determined conclusively at a previous stage. Allowing the same would run contrary to the consideration of fair play and justice. Then another Supreme Court leading judgment is quoted based on need to giving
Although the Supreme Court did
finality.
not spell out, Mr. Mitra, here Order 22 Rule 5 is a different paradigm. I mean, in fact, Order 22 Rule 5 specifically mandates the court to adjudicate that question. So if there's a specific adjudication under Order 22, probably the court meant in paragraph 54 Order 22 Rule 5. So if there's a specific adjudication on that, it's an adjudication
Yes.
which operates as res judicata.
Millard,
But
normally
if the initial one was Order 1 Rule 10, we have some doubt whether the reverse should apply.
Yes, now regarding a doubt may have been Millard, I'm not saying that any finding in interlocutory judgment will be res judicata.
Yes.
You know.
Yes.
That only. But
there has to be an adjudication.
But if a question of maintainability of suit, suppose,
yes,
or maintainability appeal,
yes,
is raised as a ground for issuing the stay.
Suppose Order 7 Rule 11 is filed.
Yes.
That is rejected.
That can be. Yeah.
Then it cannot be raised as an issue.
Suppose in this, what happened in this case? When they applied for injunction, interim order, they said order of DSO is without jurisdiction because he had no appellate jurisdiction. And therefore, order is bad, void. And that point is finally decided by that bench, saying that no, we hold appeal is maintainable.
Yes, yes.
Finally decided.
But here in the impugned judgment, it has been held that that's a pure question of law, therefore res judicata would not apply. That is one of the distinguishing factors which was considered by the tribunal. Tribunal says it's a pure question of law, somehow it says. So therefore, whether appeal is maintainable or not is a pure question of law.
Yes, yes.
So if so, then res judicata strictly does not apply.
Right. Number, if res judicata applies, right or wrong doesn't matter. Wrong order can be res judicata. Now, what this tribunal did second time, he goes into the merits of the requisition, maintainability, and allow the re-agitation of that point, a subsequent stage. May I say, what normally we all think interlocutory orders are interlocutory, that's the merits of the matter. One of the merit of the ground one of the grounds for appeal before LRTT was that this order of DSO is without jurisdiction. It was beyond appellate jurisdiction. And that point was argued. Judgment was cited by both sides. And the court rightly or wrongly held that no, its appeal was before DSO was correct and maintainable. Now, therefore, question arises whether this finding of the same tribunal in the same proceedings could be re-agitated before another presiding officer. That's all.
True.
Apart from a judicial decorum, I'm not going to.
Judicial decorum, committee of courts in a domestic sense.
But this is the question. Supreme Court puts it as a finality.
Yes.
A wrong order is final.
Understood.
The Supreme Court passes an order, my lord. Sometimes we feel the order is wrong, but it is deemed to be correct because it is final.
Yes.
We cannot say that you.
Very good way to put it.
Is it in very well? So, my lord, this is the ground I'm putting. And Sita, I wouldn't say it. If the maintainability point, as my lord also observed, a proceeding taken, appeal is not maintainable. Actually, order was not, order would have jurisdiction non appeal before DS was not maintainable. And it strikes at the root of the matter.
Yes.
Then that point is decided.
Yes.
From that, my lord, they prefer a writ petition before the High Court, division bench. A grounds were taken that this court are in holding, it is maintainable. But the judgment last will find no argument was made that this finding of the DSO or the finding of the interrogative in the stage was bad or good. No argument was made. You set aside this observation. That is what appeal was, it was filed by division. And this point was not urged, although taken the grounds of appeal. So, my lord, what? So, my lord, this order of the regarding a judgment of let us say first bench of the tribunal
Yes.
became final, and it has merged into the order of the High Court. So it has order of the High Court. So this was not contested or disputed. So it has become final. It has just similar. I on the question of this point should not have been allowed to be considered at all. Then the question of right or wrong, different thing. Is not this judgment then goes on. Calcutta High Court will not a full bench judgment have been considered of 1928. Let's see, paragraph 57. I'm happy to find 98 judgments are fully. One, yeah, what I'm just now submitting, underlined portion. Question whether decision is correct or erroneous has no bearing upon the question whether it operates or does not operate res judicata. The doctrine is that in certain circumstances, court shall not try a suit or issue, but shall deal with the matter and foregoing matter. In this circumstances,
threshold bar actually. Threshold bar. I don't look into whether it's correct. I'm not sitting in judgment over my own coordinator.
That's right.
Yes.
And my lord, this Calcutta High Court, I'm happy to find, my lord, Supreme Court has quoted in extension with approval. I'm sorted with conformity.
No, Calcutta High Court old judgments are
That's
right.
I'm very proud that then
The problem is
69
not with the
Supreme
old
Court,
judgment.
Justice Hegler's judgment.
Yes.
What is jurisdiction? And he stated, I can do no better than quoting Sir Ashutosh Mukherjee.
Yes.
What he said, well, extensively quoted. A judgment quoted, my lord. So, my lord, I am on the basis, I'm saying that there's no scope of any doubt that at the interlocutory judgment, they raised the point of at the threshold of the admission, and they invited the court, allowed the according to the court, decided finally. It's not end of it, Miller. Another judgment, Miller, of more recent, 2026 SCC online, SC 860, only read paragraph 35. The coinage of the expression interlocutory res judicata. You will find here. Now it is paragraph 35. Put it up. You got it, Miller?
Yes, para 35. Interlocutory res judicata within court term.
Public, based on public policy, that there must be final adjudication. Two stages of same proceedings.
Yes.
The paragraph that's lawsuit referring to order 37, order 7. Issue was raised in IN number. Issue was raised in IN number 4, whether the plaintiff is liable rejected on the ground that suit is barred by the order held in terms the plaintiff cannot be rejected at the threshold. High Court in the impugned order sought to avoid appeal. Then evidence explanation also relied upon.
If there was a conclusive adjudication, if it was said, suppose that it should be put to trial, then there is no question of conclusive determination.
If the party raise a case for them.
If conclusively decided at the threshold also, then that operates as interlocutory res judicata. Yes.
Well, then elaborately, Miller,
yes,
all these other judgments are noted. Then on merit court considered it. Elaborate up to Miller, this goes on. Paragraph 41 of the negative, answer in negative. This is one thing. But now, on merits also, I say, Milord, that it is, if you find out things that LRTD could reconsider the matter at a stage, if minor things it can do so, then I submit that reasoning given by LRTD is wrong. What he has said? He has said 55(7)(b), chapter 5 is not included. Chapter 5 is excluded from section 57(b). Well, just take the section and find that section and how erroneous on the face of it. Chapter 5 was not excluded. Clearly, if you just care to read the section even. Section 55, 56, no? 55. B. 57, 57. 57. Hmm. 57. Similar section 57(b) is that where an order has been made under subsection 1 of section 39, directing preparation. Section 39 in chapter 5, the beginning of chapter 5. Then another record vision record. No civil court shall entertain a suit application by the determination of rent administrators, including. Then also,
no, the revenue officer's authority has been enumerated in subsection 3, which refers only to subsection 2B. But 2B also does not restrict itself to chapter 5.
Chapter 5 not
Any
excluded.
determination is involved whether a person is a riot or an intermediate.
But section
wherever in the statute.
Right. Okay.
So it's very
Section
clear.
39, chapter 5 preparation.
Yes, yes.
Then remedies provided under appeal and section
Probably
44.
tribunal will say-
All chapter
Yes,
5
so
provisions.
the probably tribunal proceeded on the erroneous notion because 57B features in chapter 7, whereas 47 is in chapter 5. Probably
5.
that was the.
Therefore, that is again whether this chapter 7 refers to chapter 5 provisions, expressly refers to. Then how can you say it is excluded?
Entitled to one's opinions.
That is, yes, I'm showing you that.
Still it is impugned.
They may not, please, কিছু বলবেন না other than repeat করলে আপনি position ইয়ার কিছু আছে না কেন Doctor, can they give me, you know?
Yes, yes. Please impress upon me what you said just now. In Bengali. Yes.
Huh? What? They were in the field before the.
That is what we are scared of.
Appeal appeared. They were appearing. Huh? No, my lord, may I? Let me summarize my argument. I have submitted that the copy order should not have been looked into.
Yes.
I have not submitted anything that why this order expressly fabricated. Now let me decide, submit also on that. Is expressly fabricated. My lord, kindly come to that order which is shown to your lordship. Number 1, it is no list of any land schedule not enclosed. So, my lord, a mill premises, land comprising the mill premises has been allowed to be detained. May have been. I have no objection to that. Why should I object to it? Particularly now, see the two things. Is the mill premises and this plot 104 attached to each other? Contiguous? No. They are separated by a public road, a children's park, etc. This I'll show on record. Number 1, I show you. So on the record, I can show you also. This is 1. Number 2, apparently Bardur was conscious. Page. Actually, I'll tell you not supposed to give the what I will find that. Next minute, next ground.
Just put it in written notes of arguments, refer to the page number. These are sufficient.
I'm just bored. But the map, etc., is there at 297 of that annex. Number 2,
yes.
Apparently Bardur was conscious that this copy order do not at all help them in the matter. So, what they thought of preparing an annexure to that to saying that is annexed to the copy order.
Mr. Mitra, that annexure was placed for the first time before the tribunal or the SDO?
Tribunal. Tribunal. Huh?
For the first time? That annexure.
Annex is annexed before DSO also.
DSO
has all noted, produced the annexure original and,
yes,
and before that also. Now, annexure, my lord, mention lot of plots of land.
Annexure also contains Barju's stamp and certification.
Yes, one of them, plot number 104. We have shown before the court that it contains several plots of land of which government was owner by reason of acquisition of that plot of land before. Details are given in some cases. That several plots of land.
We get that.
Against, before 1964.
No, why do we get this?
Yes, we have said that on record. No, I can, no. ওখানে বলেছি বেশি করে বলেছি কিন্তু তিনটা অ্যাকাউন্ট আগে দেওয়া ছিল তিনটা আগে now my lord
order 14 rule 27 before the SDO
order 14 rule 27 application made here and in that my lord you have given the list
that probably would be going much beyond the scope of this writ petition because what was not there
but that was
even without going into that probably we can be on the veracity of
argument written notes argument দেখো But in the case, petitioner case is that There's so many parts number 1, 2, 3, number
Some
serial.
were acquired by the state.
Acquired by
which you came
state,
to
we
know
came
later.
to know afterwards. And you have made the inquiry and give the concrete proof, matter of record. Matter of record. Hmm? Another third one coming to. They have themselves say there is an order of detention of 1961 under 6.3. And some of the plots in annexure of 64 order was retained in under 1961 order. That was also given the list now. Now, let's really consider whether this evidence you have given is matter of record and whether that should not be, why that should not be considered. Because it shows, question is whether the annexure is fabricated. Apart from the question, it is certified by Bad Company not admissible at all. I'm showing it to show their anxiety to fabricate a document which is expressly fabricated because that includes several plots of land which could not be allowed to be detained under 6.3. These lands are not held by intermediary. These lands are owned by the government, state owned. Under 6.3, let's like to look at the section. No, seen it. 6.3. It is a land held by, retained by. It's a question of retention.
The state's property also vested in itself. That is to be taken.
And then, therefore, vested, but the property was held by intermediary.
Yes, yes.
Order is of order retention, not acquisition, not a gift. So the person must be used for mill premises, and you are doing so. Now, another point that mill is not running any longer. When in close, the Bard Jute investment was subsidiary of a Bard Jute company, Bard and Company Jute. Now, Bard and Company was taken out by another government named long name. That company has gone into liquidation and they're winding up new act under IBC code. And that holding company of Bard Jute has become gone to BIFR 6. And the Bard Jute is now not running the mill at all. The mill is closed. And see the distance between the mill and ourselves. But see that.
This is not a run-of-the-mill case.
Hello?
It's not a run-of-the-mill case.
Could not be. Was not comprised in the mill. I was showing this land was never comprised in the mill. The report of the court appointed by the DSO, land was and is not a factory. Both is not and it was not a factory.
You have a larger point that different MOSA, different plot, apart from this document not being admissible at all, and so
different municipal
no
number also.
Yes. So there was no identity between the jute mill and so-called jute mill.
And I'm only showing me out their map disclosed by them and except
Mr. Banerjee has prevailed on you. Which page?
At page 297. Similar. We have disclosed that. Yes, we have disclosed that. Similar to the Dag number 104. First Children Park, then Metal Road, then a Jheel, and thereafter Ultodanga. 297.
296.
And the two. This is Himanshu Ball. Kindly come to page 290. I have to see the first thing, Milord. See the map 297.
The striped one is the suit plot.
Plot.
That plot.
Yes. plot.
Yes.
It is first a children park,
Right, right.
then metal road, then a hill, and thereafter
The boundary of the bond.
boundary wall of a Badjut. Mill premises boundary wall starts. Mill boundary wall starts.
Why do
the handwritten under Urto Dama.
no, where did you get this? I mean, why should you look into it? This was a part of the record.
Yes, now kindly come to page previous 296. That read the document.
All right.
It is written to the land reforms officer by Himanshu Paul and the SRO attached to the land. Approve subject reference stated above. If draw to attention, understand, inspected the RS plot number 104 at the center AM being accompanied with Samuel Naran Bose, etc. I mean, on inspection, it is revealed that the present plot number 104 is covered with boundary wall and multi-storied buildings,
This
which is
a
under
Himanshu Baul or
construction.
Ball?
The boundary wall is ours.
And now our this 104 is our boundary wall. Now, it is also mentionable here that the dilapidated boundary wall of the jute mill is far from the suit plot. Far from the suit plot. But these are the facts of before him. He did not deal with that. So, another ground for asserting this order in submission is, it is what we call non-advertent material facts, which we call legal perversity. Legal perversity. This is what has happened, the constructed building on that. They tried to get injunction against construction, didn't succeed. So, client has constructed with sanctioned building plan duly and getting the name in municipal records. Our name is recorded. And ROR, RS, our petitioner's interest is recorded. Petitioner's name is recorded. Now, last time the petitioner's son wanted to have record, etc.
Yes.
We bought it from, not from them, we bought from a respectable BP Poddar Foundation and paying by registered deed conveyance. And after we started developing the first store, then comes the opposition. As it usually happens, it happens on. Then comes this opposition. That our submission is the state officers have acted in hand in glove. Like we say, made a place and you can show it from the copying of the grounds of appeal, etc., prayer, etc. And that their condemnation appeal application, condemnation appeal also, they decided to prefer an appeal state after the interim order was refused by the tribunal. There is condemnation appeal if they said before. So, my submission is they are hand in gloves, they're really one party. And learned tribunal had no basis for passing the order. On what basis, what reasoning he passed the order? He relied on a copy order. He has not relied and not held that possession is with us, with them. Then on what basis he could direct mutation? Not title is also not there. Title is not material, but possession is admittedly with us. Recovery of possession, they have claimed a suit. And the title suit is pending, filed by them. So, kindly set aside this order and let us have to.
Mr. Mitra, when will you argue? And Mr. Dhar, if you want to argue, you can argue now, and we can hear. So, when tell us, Mr. Mitra, when.
Next Thursday.
Sixth. Thursday time meeting.
Next Thursday, the 6th. Every day is the same for you, Mr. Mitra, now.
No.
So, Thursday, Wednesday.
Fridays are, my lord.
Easier. Fridays, we take it easier also by sitting singly. Friday, actually, Mr. Mitra, we are telling you, Friday, my single bench matters are reducing in the appellate very much, and in the original side also. So sometimes it happens that on Fridays there are one or two matters, then we sit in division bench. We try to keep one day for Justice Bhattacharya as single bench. But we fail in doing that because my single bench is getting over soon. So if we can do that, we can, but fixing it on a Friday means that we'll have to sit. That's difficult. So you can keep it as a part-heard matter on Thursday. And if you're in difficulty on Thursday, then, and if you have a bench on Friday, we can take it up on that. Whenever you tell us, you give us a date. By default, we don't sit in division bench on Fridays. That's why we cannot fix a matter on Friday. That's the difficulty. Otherwise, we have to next for the next Saturday when we.
No. I will not make that mistake again.
It was our mistake also.
I was very happy that while
underestimated research Banerjee, Roy Chaudhary and Mukherjee.
I immediately calculated and thought that, oh, first is Saturday, so.
Yes, we kept these matters only in the high expectation that this will go. Yes. So, but we are keeping it as a part-heard matter. Let it appear in the list on Thursday. If you're in difficulty, Mr. Mitra will not trouble you.
The next Thursday.
Next Thursday.
The marked part happens. So no,
yes, mark. We are marked.
This is the third time I have appeared in court on Saturday.
You appear every time?
Yes.
You have a fascination
one,
for Saturday.
one I remember on Friday, matter was going on. The Division Justice Bimal Chandra Bosak.
From then?
Yeah, then that time. When Milord
you are a history sheeter on
another contemporary Justice Chittotosh Mukherjee. He being very conscious, he first considered whether he can sit on a date which is not fixed for sitting of court. By the here matter fixed for hearing, sitting of the court fixed by the order of Chief Justice. Then there is no order of Chief Justice fixing the matter for hearing on Saturday.
Now
so,
it's always the
yes,
Justice.
And we have to take the formal order from Chief Justice.
Yes,
and it was taken. Matter arguing on Friday, matter was going on, matter was urgent. So Justice Bosak said, I'll take it tomorrow, finish it. Well, no one night.
Mr. Mitra, you have also appeared on Saturdays?
No, this is my first.
It's funny. I mean,
I was mentioning it because I appeared because on a Saturday, which is not a fixed date of hearing at all. At that time, we had 210 working days. We don't have to be miserly about holidays. 210 working days then had.
We also now also there's it's 210.
It's more.
It's more now becoming.
12 yes. 212.
Now
16, 200, 16, 17 possibly once I count.
200 probably. We are not interested in number of court days at all. I can assure you that.
When the 210
number of holidays, yes, but
working days were previously unlimited. The question was who can fix. When the 210 working days were fixed, the matter was challenged by the advocates.
Oh, that's naturally.
In the court number 12, before Justice D.N. Sinha. Mr. Ellis Meyer appeared in person. He argued from the witness box. That's why the jurisdiction of Supreme Court to fix the sitting of the High Court. And then other counsels of Mr. Suvimala, etc., all appeared. And Mr. Daftari, Solicitor General, he came to argue for the stay.
Oh, Mr. Daftari had come.
It was heard by 3 judges' bench. And that is the only matter in which I believe Sir S.M. Bose appeared before his son-in-law. He was one of the judges. And then judgment was that, yes, Supreme Court can do it.
Can do it. So,
can it be two prayers, my lord, instead of, my lord, can it be on 12th if it is?
We have no difficulty.
Because I would like to, my lord, hear Mr. Dhod also, and I will try to arrange my affairs.
Whatever. Then 12th, we will keep it on 12th.
Yes.
You can do it on 12th.
No difficulty. Hard learned senior counsel appearing for the petitioner, writ petitioners, full stop. Hard in part, full stop. List the matter for further hearing on August 12, 2026.
No.
And
But-
my lord, can I have?
We could not want to file the evidence.
Thank you for not. Keep it.
Evidence in opposition.
No, we'll take it on the next. We are not. We are done with today. So on the next day, when you start arguing, we will take.
We will be relying on this.
No, we will be.
Yes.
And can I have one more indulgence, my lord? Can we make copies of the paper books, because we have the petitions, we don't have the paper books. I don't say that it was not served.
You are the state, Mr. Mitra. If you want, you can make copies.
No, without.
We can grant you. Copies can be served on it. You don't have copies at all in the
Paper books we don't have, my lord. That is why, my lord, I could not, my lord,
acha.
track the pages.
Then how can?
আমার সাথে করেছে তো we have served.
No, I don't say that they have not served, my lord. I can't say that.
No, instead of taking out photocopies from the court's records, Mr. Mitra, I think
If they
can help you out.
Will give answer.
If you have to take out photocopies, take from their copies.
it would be very helpful, my lord, if they serve.
They will.
We are eager to help you in the interest of justice. I hope you will serve justice, not state officers.
Listed বলে দিন।
এটা আমার
Which one of you? বুধবার পাঠার থাকবে লিস্টে?
Mr. Dotto was cursing me since morning. Don't find him now.
No, he's immediately beside in the blind area, blind
He
zone.
says he's there.
Yes.
So he
He
also
does not deny that he was cursing you. The more importantly.
Citation বেরোবে। একটা তো আছে। One is left.
Mirror 5 is there. Mirror 5 is my matter.
Keep on coming. Mr. Nilanjan Bhattacharya came and said that he had taken consent. He had informed the other side.
No consent has been taken. Only he called him that I will mention the matter. No notice was given. Nothing has been given. No consent has been given. I am waiting since 10:30, Milord.
Yes, we have seen you. Mr. Nilanjan Bhattacharya specifically said, he mentioned the matter, and he said, he was mentioning, we never allow out of turn mentioning. Because of today's special circumstances, we said that whether he has informed the other side, no. He said he has informed in a sense that he has taken consent, obviously.
No.
notice was served. Can you, do you have his phone number?
Yes. Milord,
ask someone to call him up. We'll take up the matter then. We did not take consent. We were given the impression that you were informed and you have no objection.
No. For doing the matter, Milord, I came from outside yesterday night.
No, we didn't know that. We don't know who is appearing in the matter.
Okay.
Out of the turn, he said that he has informed the other side and that
There is an urgency in the matter. That's why I mentioned the matter. Your Lordship was pleased to post the matter.
we were under the impression that in all these matters there were urgencies. That's why we made that mistake in the earlier matter also. Just inform Mr. Bhattacharya. You are in 5.
I'm in 6.
Is 6 a small matter? Mr. Sharma, you are there. No, cannot be a small matter.
It can be a small matter. It can be a small matter.
Then in the meantime, just inform him. We'll take up. We'll take up 5.
Mr. Banerjee also agrees a small matter.
It can be a very small matter if, my lord, the election is conducted as per election as we understand. Election is conducted. I don't blame the election officers. Your Lordship will kindly recall, election officers are appointed. I don't blame them. I only say that they were misled to understand that, my lord, the election was done in a proper procedure. Now, my lord, what I submit is, my lord, the election happened here with a single candidate.
Okay, bolte the things.
Now, are you challenging?
Well, I'm the appellant. My lord, what has happened? May I
briefly give the back.
আমাকে দিতে দাও না। My lord, the Lordship's first order down, Ekbar. Lordship's first order in the Barkoro first hard copy. Lordship, when we had come before your Lordship on the first day, my lord, the defendant number one is an unregistered association of for the welfare of women of a particular Maheshwari community. Now, from the plaint case,
Before my learned senior friend continues, my lord, may I submit the my lord, exceptions to the report filed by the election by the special officer?
Have you given copies to them?
Yes. No, my lord, just before I show your Lordship's own order, my lord, just a brief background. My lord, this was an association. Now, the plaint case, which I understood from
The name of an individual.
No, that is individual is the appellant. There, the plaintiff is Jamuna Heda versus defendant. Respondent number 2 was D1. That is the association known as Bahatar Kolkata. Unregistered. Now, plaint case is only 3. They agree.
Registered association cannot.
That point we have taken. Order 1 rule did not take. That point is their Lordship orders notices. Now, to cut the matter short, they have two grievances on the plaint. One is that adequate notice of meeting was not given.
You are a defendant.
We suffer the ex parte order. So they took the first point is adequate notice of meeting was not given. Meeting was fixed on 31st March. Second point is that some genuine voters are excluded. Therefore, the meeting which will be conducted will be an illegal meeting and it will not reflect the exact correct representation of issues of the members. These were the two grievances. Other than this, there are allegations that not relevant. Now, to cut the matter short, page 87 in Can 3, we have an XD order. Can 3, page 87. The order is of 19th page. Page कौन सा है? मतलब I don't know what page Lordship है. Can 3 থেকে order দেখাচ্ছি.
Can 3 we don't have.
হ্যাঁ, we have সব করেছিল. Can 3 ঠিক আছে. Order Can 3 order দেখাচ্ছি. Can 3 আমার কাছে serve আছে. Kindly come to the first is the 14th May order. And
আমার কাছে served আছে. What do you mean? You have not served him and you say.
No, we have served. We have served him, but Mr. Sengup.
Service আছে there.
Service আছে. My Bengali is not that good.
Bengali is very good. আমার কাছে serve আছে means you have been served.
No, we have served them. Now, Lordship first order, Lordship was found 14th May.
Yes.
Now, 14th May here, Lordship notices the objection 1, 2, 3, 4. What are the objections? Now, come to the next page, my lord, the 19th May order. This is the most important order. 19th May, my lord, paragraph number 2. This is the plaintiff submitted that the bylaws so and so were 19th May order.
Yes.
Now, kindly come to the first, the Lordship is taking note of the allegations and counter allegations. Now, kindly come to paragraph number. Para 12. During argument, so and so offers an ad hoc solution. Now, come to para 30. It is submitted that an election may be held in terms of the agenda already fixed by including without prejudice to rights and conduct party all voters who were already listed by the appellant as well as the voters alleged by R1 to have been excluded. So, first point is agenda will be the same. Lordship has not used the word, I've checked many times, Lordship has not used the word fresh meeting. Kindly make a note, quote unquote fresh meeting, because fresh meeting will be found at least 100 times in the exception affidavit. Lordship order does not direct fresh meeting. What does Lordship order direct is fresh notice, which is at page 4, para 14. So first point is Lordship order is agenda already fixed will be the agenda in the meeting to be conducted under the supervision of the joint special officers, number 1. Number 2, their main point is excluded voters should be given a chance. I said, please allow them. Paragraph 13 notices that excluded voters will be allowed to participate and that issue is covered. My learned friend is not agreed with that excluded voters have not been included. That is covered. Para 14, fresh notice. That is also done. Not a case.
This was one of the bones of contention.
Yes. So both contentions satisfied. Now come to paragraph 15. Election we had under the aegis of the special officer. Now paragraph 16 is very important. Learned counsel for the R1, which is Mr. Banerjee, does not have any objection. In principle, subject to the writer, it will be without prejudice. Now, what is his? So he's agreed to two things. Agenda same, fresh notice, excluded voters included. I will show all three things have been done. Now, kindly come to paragraph 70, name is given. Now, my lord, kindly come to paragraph 19. Such election will be held in accordance with the voter list to be prepared on the basis of voters who are already included. This is all done. Now come to the most important paragraph. 21. This is one more allegation which will Lordship will find. 21. The venue and modality of election will be decided by the special officers in consonance with the bylaws of association, if necessary, in consultation with learned advocate for the respective parties. Now, here the learned special officer gave the first notice for convening meeting. Meeting was convened upon notice. The admission, the notice is not in the challenge. Everybody got the notice, but respondent number 1 was not present. They chose not to be present when the learned special officers were fixing the date and the venue of the meeting. Now, one objection is this. So their first objection to they are taking exception. One ground is that the learned special officer did not change the agenda of the meeting. Why? Not they had made a request for including Jamuna Head as the plaintiff to be the nominee as the president in the meeting to be conducted. Why they made this request? Because they have come to know, but there is no document on record. They came to know that the election with 2 candidates has now become only 1 candidate, because one candidate is Manju Varsha Daga and one candidate is Kusum Mundra. So there were 2 candidates. Now they have come to know, so they have made a verbal or oral allegation without any document that they came to know that one candidate is not contesting. It will be one election, one candidate. There will be no election. So to comply with the spirit of the High Court order, we propose to nominate plaintiff as the other candidate. Now they filed an application they filed CAN 2 for seeking modification, but CAN 2 was never moved before the meeting took place. Now, what has happened, in fact, the special officer said that we will go by paragraph number 13 of the Lordship order. We cannot change the addenda, number 1. Number 2, venue of the meeting is chosen to be a hall which belongs to a company known as Havra Jute Mill. They have alleged that that hall belongs to a lady known as Nirmala Mal, who is siding with the respondents, appellants. Now, Nirmala Mal is not the owner of the hall, number 1. The hall was chosen to be in Havra because most of the members stay in Hinmotor or Havra locality. And just to make a note, this venue of the meeting was fixed in that meeting when they were absent. And everything is because most of the members stay, they all ladies, they all stay in Havra. So the members made a request that why not in that hall is owned by a company known as Havra Jute Mill, not by Nirmala Mal, an individual, which according to them is a lady siding with us. Now, the third objection there.
Member of this association?
Yes, yes. So everybody, all they are member of the association, but not the owner of the hall. And there are 70, I've taken instruction, 50 to 70 functions, meetings which has been earlier held in the same hall of this association in Havra.
Then it was different. There was no.
So it is convenient to everybody.
All right.
And in any event, venue of the meeting is, it could not have been different. But when the Lordship order has, Lordship has kept the matters.
Bombs are planted under their seats.
No, I'm coming to that. Seat will, because they didn't come to attend the meeting. Where is the question of seat? All these 16 excluded voters, including the plaintiff, absented, saying that meeting is illegal, we will not participate. Now, Lordship, the venue of the meeting is an irrelevant clause.
Why was it mentioned?
No, I'm mentioning what has happened now, my Lordship. On the first day, Lordship, I had made an suggestion for this impasse, which my learned friend in all his fairness had agreed.
Yes.
Now, the question is, Lordship didn't grant the stay of the order. Lordship, I said, these are the grievances. If these grievances are taken care of, everybody's issue will be resolved. We will. Now, what is in the meeting? What happens? Just before I give you what is the urgency in the meeting, there were 75 votes, out of which 74 votes were valid. Candidate, कौन सी था नाम बताओ? नाम बताओ. Kusum Mundra got 74 votes, and 1 vote was given to Varsha Daga. So 73:1. So the candidate who is now one has now won twice. One in that impugned meeting, which is under challenge in the suit, and this is the second meeting under the special officers. Now there are 2 issues coming up. Varsha Daga, who is the other candidate, what did she did? When the special officer wrote an email, page number that special officer wrote the email to both the candidates, Varsha Daga and the other one, Kusum Mundra, that please present on the date of the meeting. Both gave an email to the special officer, we will be present. In that email also, few days before the meeting, I will give you the date. क्या है उसमें email का बताओ? ठीक से बताओ. See, both emails are on record. Both of them said we will be present in the venue of the meeting. Now, when the meeting is held on 2nd of July, both the candidates are there, And the special officer field note has made a recording that 10 minutes before the votes are to be dropped in the box or polling starts, Varsha Daga said in the meeting that I'm not contesting, I wish to withdraw. But the special officer said that that stage has gone. You had, I gave you an email, you said you will come. In that email also, you have not said you are withdrawing. Now notice, 21 days notice has been issued. Everybody is informed, members have come to vote. And the meeting process that Lordship knows in election also, like we assembly or Lok Sabha candidates may choose to withdraw, they choose to withdraw. But then when your name is there on the ballot and when name, you cannot unilaterally say I'm withdrawing. Now this point is now being taken by my learned friends. So they are saying two things. One thing is that because one of the candidates withdraw, but still they kindly make a note even in their Can 2, which they filed for variation of the order on the ground that that candidate is withdrawn. There is no document, only an oral statement, and oral statement given by somebody else affirming true to her knowledge. She has not made any statement in writing till date that I am withdrawing from the candidature. The Can 2 has been affirmed by the plaintiff Jamuna Heda in paragraph number 9 or paragraph number 9, and paragraph is true to her knowledge. Now they are saying because Varsha Daga had withdrawn, therefore one person candidate meeting could not have been happened. Therefore, I do not, we think the meeting is illegal, we will not participate. Now, on the one hand, they invite the court to pass an order without prejudice. Lordship intention was to hold the meeting to see the wishes of the members. Now, the members have expressed their wish twice. Now, what has happened, the urgency is that they have Lordship didn't grant a stay because before stay, I only gave this offer and my friend accepted.
Impugned order exactly.
Impugned order is
What is the restraint order?
There are two orders. One is 31st March. Kindly come to impugned order is the defendant 227 will not represent themselves as the members of the, they will not portray themselves as president or office bearers, and they will not participate or they will not involve in the funds and affairs of the page 23 of Can 3, my lord. First order, kindly see page 24, operative portion. Direction is given upon the principal defendant to keep all further steps in the matter of conducting election on the basis of final voter list in abeyance. So first order is voting should not be given effect. So that we are following, she is not portraying herself as president. Second order, as is at page 169 of Can 3. Second order is of that is 10th April. That is the most important order. First order, my lord, because Vakandi come to second order is 10th April. In my brief, it is 168 or 170. Lordship's brief Can 3, my lord. Here, second order says that D2 to D7 and all person acting or through them are restrained from representing, projecting the election process as valid. So none of them are projecting or saying the election has been held valid. Or loose copy don't order. No. May I hand over the 10th April order? Can you see the 10th April order? Election is over on 31st March. They filed another 151 application, and which the 10th April order is passed.
Page 169 or something you said? No.
My brief Can 3 170 or 168. Lordship 169 starts at
page 168.
Yes, 168. This is the order number 3, operative portion ordered after the heading ordered. Lordship found the internal page 3 of the order.
The one which you handed over?
Yes.
Yes.
Can you see the second, third paragraph? Defendant 227 and all person acting on the through the under are restrained from representing, projecting the election process as valid, complete or operative. So stopping here for a moment. So first order is that these D2 to D7 will not give or project that the election process is over, valid and complete. Therefore, they should not act on the basis that the president who was elected in the meeting is the president. So president should not assume of
the injunction application is still pending.
No, my lord, there is one more serious thing happened. I'm taking one more minute. Second portion, they are further restrained from publishing, circulating, giving effect to the result of so-and-so, and this portion, and attending or accepting any recognition, felicitation or office bearer pursuant to the impugned so-and-so or any kind of legitimacy to the election process. And above that, they are saying they are restrained to deal with any fund record or affairs of VKPMS. Now they have filed an application for contempt. Now Lordship appeal is pending. Election, before the election process is being held under the supervision of learned special officer, Lordship did not grant stay of the order because this process we were trying to adopt. Now they have filed order 39 rule 2A, which is annexed to this very Can 3A. Can 3, that is at page number 228 or 229. Can 3 has
Contempt on what? What have
on
you-
ground. They are saying
Yes.
they are saying in the contempt that they actually want the entire functioning of the association to be stopped. This is a philanthropic social organization. We distribute umbrellas, we distribute gifts or some type of things to the weaker section of the Maheshwari community. Now they're saying that because D2 to D7 or some of defendant participated in a function, therefore you are acting in contempt, you cannot attend any function, means no function of the organization should be held. The order does not, in my reading, does not say that the entire events, the society can hold events or the association can hold events, but D2 to D7 cannot project themselves as the office bearers or
In the notices of the events or something you have made.
yeah, in some function, one or two defendants attended the function.
Not attending. Did you give yourselves out as
President? No. President, Malad, the lady who was elected
how
as
did you convene the meeting?
Malad, not meeting, functions, not meetings. Like function.
Nothing was convened.
No meeting. Function like for
Of the community.
of the distribution of umbrellas, some social philanthropic work function.
They were published anything or
No, it is under the banner of the society.
Achha.
But the ladies of the members of the association.
There is no bar in doing that.
Malad, this is what they have filed is order 13 and rule 2A. Kindly see the prayer. Now that is kept on Monday. That is kept on Monday. Order before the lower court.
Yes,
No.
there you contest that.
I'm contesting, but I cannot.
What is that?
Now the
You were intending to, I mean, with whatever the special officers report are fine and their objections, would.
Lordship may clarify that the functions of the association cannot be stopped.
No, of disposing of the appeal and directing the learned trial judge to decide the injunction application merits. The outcome of this election process, as per our direction, that will be subject to the outcome of that.
Malad, they have filed an exception. Now the learned court
That will also go along with that.
Malad, that the High Court order is there for conducting a meeting. They have filed an exception. Malad, if
We have not conclusively decided because it was submitted by both sides that election may be held.
yes, election, Lordship has said the order is without prejudice. But kindly see the exception affidavit, what grounds they have taken. Malad, their conduct is not fair. Kindly see two paragraphs of the exception affidavit.
Place the demerits myself.
No, sir, may I? I've not finished, sir.
Demerits of my exception, may I place myself?
Sir, I've already placed the report, two paragraphs only, my lord. Kindly see two paragraphs of the exception affidavit.
No, now we don't still understand why are you mentioning this today. I mean,
My lord, the Lordship, the functioning of the association.
They have filed a 39-2A. You contest that and say that this is not part of this order.
I'm saying
Who
that
does that give an urgency to the event?
Lordship may hear the appeal. Issue is very short. Lordship may hear the appeal on any day.
Issue is short. We understand by now.
Yes, issue is short. And kindly, in the meantime, Lordship may clarify that the functions of the society. I'm praying for the functioning of the society should not be stopped. Election process that may be a stay. I will not project myself a candidate. But Lordship, how long can
we are not hearing your exception or not deciding on the outcome of the election right now. That will be that we will do. We'll take into consideration your exception and also decide on that before disposing of this appeal. But for the time being, how can you say the functioning is restrained by this?
I follow. But may I make a humble submission to the
limited order to the effect of explaining this.
If not, I have a few humble submissions to make.
We are not granting stay of this, but we'll explain. We'll clarify that this cannot prevent you from the society from organizing functions.
That can certainly prevent the society from filing reports in the name of the president before national bodies. That is happening.
No, we are not touching upon your contempt
So
application.
therefore,
No report has been filed.
no violation has been committed. That is a defense to be taken before the proper court.
Yes.
And Lord, I have taken all those allegations. I have substantiated with documents. But that they have to defend there. But
Yes,
Lord,
Mr. Sharma, he has a point.
Kindly give me 1 minute.
We are not hearing.
No, I'm not.
One thing.
Kindly read one paragraph of the report and then I will leave it upon the
I
court.
didn't get the chance to even open
His
my
exception
mouth.
he will have
May I
to
just
place.
indicate one thing. Here the urgency is not
sir,
more than him, it is on my
No,
part.
my part. He
The
has
urgency
told
is
the
not
functioning.
my part. Because my lord, the bylaws say, my lord, the outgoing board shall be in force for 6 months after the expiry of after the natural expiry. The natural expiry was in the middle of February. So therefore, my lord, good, bad, indifferent, whoever is running the show, my lord, today, my lord, today the board which is outgoing is supposed to be the board which is conducting the functions. Now, my lord, that board will run out of office under the bylaws in the middle of August. Now, that is the urgency with which I stand today. And Lord, if I may just indicate, Lord, the agenda. It has resurfaced before your lordships a number of times. If your lordship can kindly look at the agenda once.
But we directed that agenda to be followed. While
My lord, in that event, my lord, there are directions of this honorable court, my lord, perhaps my lord, the learned trial court will, my lord, the agenda needs to be, my lord, interpreted here. If your lordship kindly looks at the agenda once and kindly interprets the agenda, but the agenda speaks about, if your lordship kindly comes to page 39.
We'll look at the appeal along with the
Yes, my lord,
application.
I am not
Keep it
paying.
And in the meantime, kindly only pass, Manala, kindly the proceedings, Mala, they should not
We'll
proceed
not
with the
stay in
order
the
30 and
order,
rule 2A for the time being.
No. Right.
Mala, then lordship is hearing the matter, Mala, only one
The
paragraph.
court granted stay, they can
Kindly read one paragraph of the exception affidavit for my only one paragraph.
Exception we're not
taken
taking
out.
note of.
Mala,
Why should
this
we?
will show the conduct, how they are Mala, wrong interpretation of the order deliberately is an act of contempt. Kindly see what the audacity to write.
Clarify that we are keeping.
No,
the
kindly see
application.
what they have written. May I read, my lord? May I read paragraph 23 of the affidavit? The order directing a fresh election, which I've told you never there. Order directing a fresh election was passed after this court considered the rival submission of the parties and the challenge raised. Paragraph 24. The expression within quote unquote fresh election necessarily require the learned special officer to conduct a fresh electoral exercise. They are deliberate misinterpretation of a high court order is an act of contempt. They are obstructing the administration of process of justice by making the order. Order does not use the word fresh election. Who gave them the order?
Subject to you interpret our order. We have passed our order. That is on record.
Yes,
Why should
but
you go
my
and
lord,
explain
they are saying because the court had ordered a fresh election, therefore the special officers.
Show this order to the trial court and say and argue, Mr.
My lord,
Sharma. Defends you.
My lord,
Our order is on paper.
Correct.
We are not. We shall not go personally and explain our order.
No, I'm explaining you, ma'am. Your lordship not hearing the matter.
That before the trial court, this order is with you. I mean, this order is on record. You cite the order and show.
My lordship, today, my lord, the president has won 2 elections, good, bad, indifferent. Now somebody has to run as an ad hoc member. Let the
Out of 151, 74
Will
participating.
not give a sanction to the election right now.
No election which were conducted in the court's order, at least for the time being, till the appeal is, till the matter is being heard. We have filed order 13 and rule 4 also.
What election? The results won't have any effect right now.
Lordship, that is what they are wanting. They want there to be total limbo. Nothing should function. They want the functioning of this a very, if I can use a very unofficial association working for the philanthropic activity. They don't want it to function. It is not involving hundreds of thousands of crores of rupees. It is working for the betterment of a particular section of the woman.
May very simply join issue here. My lord, the bylaws say that the outgoing board will function for 6 more months.
You are not a registered. How can you help?
Lord, that if I may just indicate, Lord, if I may indicate, the registered association is made a party. But
It's
finally,
not registered, it is unregistered. my
unregistered,
friend.
I'm sorry. Unregistered association is made a party. True. My lord, good, bad, indifferent, my lord, that will be decided by your lordships. But my lord, all the allegations, all my lord, the
Unregistered association, how can it get an injunction?
Lord, everything has now culminated into this order of 19th May. Lord,
Nothing
the
has
19th.
culminated in anything. You should have said that order by saying that this.
Lord, if your lordship kindly looks at the order of 19th May, your lordship is saying, Lord, 19th May, we
have
both
not
agree.
decided anything finally.
Yes, Lord, but
No.
19th May, both of
19th
the
May,
parties.
both parties agreed. We have just directed
Yes.
the elections.
Now, my lord, so the election may be fairly conducted. If your lordship kindly looks at whatever is submitted, my lord,
The election does not pose any urgency in the matter. You have taken out an order 39 rule 2A, you move it. But we have serious doubt regarding maintainability of the suit
that
itself.
is open, Lord, they have not taken up that point
We have
yet.
taken this
The-
point. There is a
that will
notice in the
decide.
14th May order. Kindly
Court will itself take it up.
Lord, then that will
The
be
maintainability issue hits at the root of the
14th May order.
It will be, my lord, kindly let that be decided by the learned trial court as and when they
Why?
take up this point.
Decide in our appeal. The appeal before us.
Then
Let us
may I-
decide it right now then.
Yes.
But then may I try? Then may I place? May I try and place?
Was that an unregistered association can
Lord,
maintain?
I have made. If your lordship
Is it a
kindly looks at
juristic
the
entity?
plain-
Was any law?
But there are my lord,
Who are
other
the
parties.
plaintiffs?
The plaintiff is a member
Of an unregistered association.
of an unregistered association.
Which is also, and there is not a member we are saying.
That we
You
can.
are you agitating your personal issue or as a member of the society?
But as a member of the society, I am entitled as
Can
a
you do
patron
that?
member. As a patron member, my lord, I am only trying to.
If there is no registered society, can it? I mean,
But if I may
it
humbly
can't
submit,
even hold funds.
Lord, may I humbly submit this? My lord, the other defendants, they are all members who are running
No,
as my
but
lord,
Mr.
presidents.
Sharma and you, we don't find any urgency in the matter. We'll take it up in usual course, but we'll keep the appeal for hearing.
I only come in the usual course
6th of
only.
August.
Today is a usual
It is
course.
not
my
an
lord.
issue for us.
Court is open with the usual course. We only took a chance that lordship, this will be less burden. That we have not In all, Lordship, kindly take on. We have not done anything which is.
Had you mentioned this matter for?
No, it is
just
perhaps
hold on.
not.
It was called on. It was called on Tuesday when they took Passover, and I was to take a flight. So I had made a prayer for 31st. Lordship said, "You come on first." So nothing was mentioned. So let it come up on list on Monday. We will take a chance.
Lord, just for the record, may I deflect a few of the submissions made? Otherwise, Lord, I will not be.
तो मंडे आके
Please.
करेंगे ना. Let the court
But it is said that the withdrawal was intimated 10 minutes before. It was not 10 minutes, it was more than 10 days before. 13th of May was the first time, my lord, a notice was sent. 13th of June was the first time a notice was sent.
Exception you are filing right now.
I have filed. All
Kindly,
yes, I have filed now. I have.
I call upon my learned friend to disclose any document in writing 10 or 15 days before of the candidate who wanted to withdraw. This is not
I
record.
humbly can do that.
But you should have done it by now.
Learned
Yes,
Senior
I
Counsel,
have
the exception to the special officer's report filed today be kept on record. Full stop. Next para. The short backdrop is that the appeal arises out of an injunction order pertaining to
14th order.
an election notice issued in respect of an unregistered association.
14th May.
Acha. Full next para. Learned Senior Counsel for the appellant argues that taking undue advantage of and misinterpreting the order of this court dated May 19, 2026, the respondents, the plaintiff stroke respondent number 1 has taken out an application under Order 39 Rule 2 capital A of the Code of Civil Procedure in the trial court, alleging that the order impugned in the appeal has been violated. For sub next para, learned Senior Counsel further seeks to impress upon the court that the election was held on consent and nowhere within the four corners of the May 19, 2026 order was it directed that fresh elections closed shall be held. Full stop. The rider associated with the direction was that the election would be held on the agenda already fixed, by including, without prejudice to the rights and contentions of the parties to the litigation, all voters who were already listed by the appellant as well as the voters who are alleged by the respondent number 1 to have been excluded. Full stop. Next para. Insofar as notice was concerned, learned Senior Counsel points out that only a fresh notice of 21 days was directed to be issued, which was duly complied with by the special officers. Full stop. Next para.
And excluded vote was also taken.
Yes. It is further submitted that the excluded voters were also included in the voters list in terms of the direction of this court. Full stop. Next para. Learned Counsel appearing for the plaintiff stroke respondent 1, inter alia, argues that the plaintiff had, more than 10 days prior to the election, indicated her willingness to withdraw.
He's a
withdrawal is
somebody
by
else.
another person.
He's a proxy.
Harsha Daga.
How can you do that?
Yes, this is
That was intimated. That's what.
without you to my knowledge.
What authority do you have?
This is
That was intimated by Harsha Daga herself.
and she's affirming that paragraph 2 to her knowledge. She has never come forward. Not a single piece of
Plaintiff here is,
paper.
my lord, indicating
This is
if
the
you
What is the name of that person?
Yeah, this is R8, my lord. Defendant number 8, Varsha Daga. In the appeal, it will be
Submits that the at
One
least
of the
10 days
contestants.
prior to the election, the intention of Vaishya Daga, one of the participants in the election, to withdraw from the same was intimated, despite which her name was not deleted. Full stop. Next para. Be that as it may, since the elections as directed by this court has already been held and the special officer's report filed, we shall adjudicate, we shall pass necessary directions in respect thereof, taking into account the issues raised in the exception thereto filed by the plaintiff stroke respondent number 1 at the time of hearing of the appeal. Full stop. these papers are sufficient for hearing of the appeal?
Yes.
Since we
Submission,
are
Your
apprised by
Lordship,
yes.
One more submission, Your Lordship. Kindly request, my lord, that my effort to make a nomination that was not allowed.
Obviously, the order does not say that.
My humble submission is
Order
that
says the same
It is submitted by learned counsel for both parties, comma, that the papers on record are sufficient for adjudication of the appeal. Full stop. Accordingly, let the appeal be listed on August 6, 2026 for hearing along with the connected application. Full stop. Next para, it is made clear that all issues raised in the exception as well as taken by both sides are kept open for being thrashed out at the final hearing of the appeal.
Great.
Order 13 contest independently. If they try to,
I know.
One submission, my lord.
Yeah, the ladies are getting feared because of this. They don't want this. They are all housewife ladies. They are getting scared by this content. Fear of course, you will put in jail, and they are writing letter. This was not necessary. We all want the peaceful resolution of this issue. If a housewife gets a notice of contempt, you will put in jail. Everybody will get scared. And what is happening? The function for the poor section of the woman has been held. Nobody is scared to go now because they will face another act of contempt.
I told you, Mr. Sharma, that housewives are so timid and scared.
Here they all aged ladies. Most of them are
erroneous premise.
no. I've got letters to show they are all senior citizens.
First
Most
of all,
of them.
gender bias. Secondly, patriarchal. Thirdly,
Senior citizens are there.
Defies common knowledge.
I will show the letters showing the fear. I can produce that. Sorry. May I have a lordship, please?
We have called him, someone has come.
Yes, Sir Bhattacharya indicated that you have.
I have been informed by Mr. Bhattacharya that Mr. Bhattacharya has called personally several times, my lord. There is some miscommunication, my lord. I'm very.
No, Mr. Bhattacharya called several times. Several times. He did not get him over the phone.
You will going to take time as because he has made a.
Did he agree?
No.
Called several times, did not get him. That is no agreement. We were given the impression that the other side has agreed to that. We are not blaming you or Mr. Bhattacharya without hearing him. But because Mr. Bhattacharya submitted that he has informed the other side. Obviously, the first question we asked him, because this is a special day, people are coming for these matters only. That is the precise reason why you asked Mr. Bhattacharya that is the other side here? This was our question. Is the other side here? He said, I have informed the other side. Informed obviously means
he called him that I am going to mention the matter. And
that is different.
Yes. Nothing
informed that I'll take time and he has not opposed, that's different. From informing that I'll mention the matter for time. No. Then we'll hear the matter. Inform Mr. Bhattacharya. And we'll record that this is not proper on the part of Mr. Bhattacharya.
My lord, kindly.
He has left court.
I'm begging not.
No, Mr. Bhattacharya has left court.
Yes, my lord. He has a doctor appointment, my lord.
Yes, he said that. He said, I have a doctor's appointment. I have left. What is the urgency, Mr. Datta?
My lord, there is an order passed by a prescribed authority that you restore the original position because there was a DOBA. So there was a specific direction. When the matter has been pending for consideration before in the original application, that order has been passed that the 415 on the basis of this, the prescribed authority will act on the basis of the 415. That is for restoring the water body. Restoration of the water body. We filed an MA application. In the MA application has been rejected by the LRTT.
For what relief?
For my lord, for staying this operation of the order till such time, our application would not be heard out. Because the principal order, which has been passed by the ADM and DLLRO, that has been under challenge before the way, that is pending consideration. In the meantime, subsequent order has been passed by the prescribed authority, saying that immediately restore the water body. Restore the water body. Then, my lord, we have filed an original application, filed a MA application. That is the miscellaneous application. That miscellaneous application, my lord.
Asking for a stay of that subsequent.
Yes.
No, but initially you could not obtain any stay of the parent order.
No, there was a principle, there was a the prayer for interim order. That interim order at that stage has not been considered, only the date was given. During the pendency of the matter, your lordship knows, my lord, in the take the judicial notice, whenever the matter is filed after 6 months, my lord, the date will be fixed.
Yes, yes.
In the interim, my lord, this order has been passed. We filed a MA application. MA application has been rejected.
Just show us the orders, Mr. Datta. The original order which was challenged?
Yes, no, I'm.
Page 100.
No.
No, I mean,
89.
89.
89. The original order which has been
Yes,
challenged.
yes, that is what.
18.
The first order, I mean, of the authority.
My lord, it starts from 88. Otherwise, my lord, chronology would not be there. It starts from 88. Otherwise, chronology would not be there.
Acha, very good. 88. Give us half a minute. Yes, 88.
Whereas it appears that the Gopal Chandra Sardar and the Manik Chandra Sardar both are the son of such and such of the Frejargon such and such, has applied before the BLLR Namkhana for the change of the character of the plot number 1681 and total involving area such and such, recorded classification Doba of the Mauja Amravati, jail number such and such, to hotel Khoitan number such and such, such and such. Whereas it appears that the while disposing of the said petition for conversion, it came to the notice of the undersigned that the subject land has already been converted and being used as the guest house, resort and hotel. Whereas it appears from the said case does not come under the purview of the section 41C of the West Bengal Land Reforms Act of 1955. Hence, the said conversion case applied in form number 1 capital A has been rejected, and consequent to the rejection, this proceeding under Rule 166 of the West Bengal Land Reforms Manual of 1991 is hereby drawn up. That is not I. That is not I.
Oh.
They themselves suo moto dropped the proceeding. Prior to that, just within a
So you sort of post facto conversion?
Yes.
Prior to
that, just a minute.
Land reforms. Yes, you continue. Land reforms.
So what happened, my lord? Initially made an application for the conversion of the land in the year of March 2023. When my application has been pending, without disposing of my application, 415 proceeding has been drawn up, asking me to restore the water body. Although, my lord, by the time that the land has already been developed.
Just tell us, we are not sure. I mean, post facto conversion is permissible.
Yes.
There is
few conditions are there. Everything is there. There is few conditions are there. If the condition is adhered to, in that event, that would be given. In a nutshell, I am giving. Yes, provision is there.
You'll be able to show that.
Yes. Subsequently, thereafter, what happened? One claiming as a public spirited citizen, when this order notification has been passed by the BLLRO, one public interest litigation has been filed. In the public interest litigation, he was the Borgadar. But yes,
this land.
Yes, but he suppressed it. And other counsel appeared, I don't know, why he did not say all those things. The Honorable Division Bench of this court was pleased to pass an order, only simpliciter, asking the authority to complete the proceeding which has already been initiated.
That is the demolition proceeding?
Yes, considering the initiative.
Then?
No. Subsequently, thereafter, I knowing it, immediately a review application has been filed.
In the appeal?
In the appeal. In the review court, in the division bench, in the review application, has passed an order saying that there is no error apparent on the face of the record. But the fact remains, whatever you have stated, liberty would be given to you to agitate it by filing a comprehensive representation to the authority where the position is pending. I made a comprehensive representation. In the said representation, I have annexed few documents, and I said that I have inherited the property, and this property has been gifted by my father in the year of 2015, and subsequently the construction has been done, and part construction was there on the previously. On the basis of which I disclosed two documents. One of the principal document, that is the tax receipt of 20th of March 1980. The provision says, 166 says, if the property in natural course of business has already been developed, and if it appears that the many eventualities are there, prior to 24th of March 1986, in that event, the post facto conversion can be given. On the basis of which a hearing has been conducted and this order has been passed. So, my lord, This order has been passed on the basis of my comprehensive representation, which has been filed before the authority pursuant to the liberty granted by the Honorable Division Bench in a review application.
No, but that has to be change in use, has to be in usual course of nature.
No, yeah, I'm coming, I'm coming.
Yes. That is the finding.
Yes, yes, yes. Then, my lord, it has been, so they themselves, my lord, my previous application for conversion has been dropped themselves, and they thought it fit that this is a case of 166, a proceeding has been drawn up. Then, my lord, kindly see, have been rejected and such, is whereby it appears that as per the provision of the section 166 of the West Bengal, 166 of the West Bengal Land Reforms Manual of the 1991, it requires to ascertain through inquiry, kindly take a note of it, through inquiry, as to whether the change in use has been made in usual course of the nature or by deliberate action on the part of the applicant or any person and the case, it should also be ascertained whether the change took place before 24th of March 1986, date of the publication of the 4C of the West Bengal Land Reforms Amendment Act 1981 and the official gazette. Then we will come have a look at the 166 of the West Bengal Land Reforms Manual of 1991. This is a special provision where the conversion has been made before making application for permission. While disposing of the petition for the conversion, it has come to the notice of the collector. So collector has to satisfy or collector has to come to knowledge that the land has already been converted to some other use other than appearing from the record of rights. Such a case should normally be dealt with under section 44. In such cases, kindly take a note of it. It should be inquired as to whether the change in use has been made in the usual course of nature or by deliberate action on the part of the applicant or any other person, and in the latter case, it should also be ascertained whether the change took place before 24th of March 1986, that is the date of the publication of the official gazette of the West Bengal Land Reforms Amendment Act of 1981. So it is obligatory on the part of the authority to conduct an inquiry. Conducting inquiry is a sine qua non.
Here nothing was done.
Then, my lord, kindly see the order itself. So they have, my lord, reproduced, which has been written over there in the first portion. Next, I have given a tax receipt of 20th of March 1980. What they did.
So hence the case has been rejected and disposed of, they say, in the first page itself. Or that is the second page.
Oh, that is.
They've already gone to the second page.
Kindly see, my lord, 89. Page 89, next order has been passed. The case is taken up for hearing on 14th of December 2020.
This is after drawing under 166, they take it up.
Yes.
Yes.
The case is taken up for hearing on the 14th of December 2023 and for disposal. The applicant remains present, file hazira, heard the cases. The applicant mentioned that the change was made 40 years ago. To the support of the such claim, the claimant has submitted a panchayat tax receipt bearing number such and such dated 20th of March 1980, veracity of which is to be verified by the panchayat. DA, departmental authority, concerned is hereby directed to prepare a letter to the Pradhan of the Frejanganj Gram Panchayat asking him to cause the inquiry and the report on the put up. The applicant is hereby directed to submit auxiliary document in support of the claim. So no inquiry was conducted. My document has been placed.
This has been challenged before the tribunal.
Yes. No, subsequent order. Then what happened, my lord? The document.
Before the tribunal in the original way?
Is in the original way.
You have challenged this in the original way?
In 26th of December 2023.
Yes. This has been challenged.
Yes.
This is the original challenge in the way.
This is the original challenge.
Subsequently, what order was passed?
Subsequent order, page 100.
The one which you are now complaining of?
Yes, page 100. All along, I am enjoying the interim order, my lord. Page, my lord, 100.
So you were enjoying interim order?
I were enjoying it. I was.
The tribunal?
Not the tribunal, by the Supreme Court. By the Honorable Supreme Court.
Okay. Now, how did it go up to? Let us see. Yes. No, the page 100 order comes after.
After.
But before that, you were enjoying interim order.
No.
Achha, after this.
After this, my lord, I filed a MA application when the order dated 30th of January 2024 has been passed.
Yes.
Directing me Kindly see, my lord, just I will not take much time. The concerned assistant engineer PWD civil category such and such is requested to take necessary measures within 3 weeks. Receiving of this order, remove the unauthorized construction, demolition. Remove the unauthorized construction such and such of the scheduled property earlier, make necessary arrangement to assist the proceeding. Now to
this was a naturally corollary of the previous.
Yes. Naturally corollary.
There is no.
Yes.
Independently, there is no wrong.
No. So since that order has been passed, it is consequential order that has been.
Sure. So what did you do then?
Just a minute. Subsequently, my lord, we have challenged it, filing an MA application. MA application has been rejected.
No, what was the way against the main order, the previous?
Main order of 26th of December.
That you had challenged.
That I have challenged.
There you did not prefer any ad interim order of that
No,
order.
there was a prayer for an ad interim order.
That was refused.
No, that was pending consideration. Subsequently, new cause of action has arisen.
Ad interim prayer was also pending. It was not refused.
No, that was also pending because the 6 months thereafter the date has been fixed. In the meantime,
the first date was fixed 6 months
yes.
after. After filing the first date is fixed.
This is normal, my lord.
No, those dates we are seeing that once it is taken up and then dates are fixed.
No.
But from the filing itself it starts.
Yes.
Ad interim prayers are not.
No, not considered. Nothing has been considered. Subsequently, when this order has been passed, I filed a MA application.
Naturally, yes.
So MA application has been rejected. Challenging the propriety of the rejection of the MA application, I approached before the my lord this Honorable High Court. This Honorable High Court affirmed the order passed by the my lord in MA application.
MA was rejected.
MA was rejected.
Then?
So I challenged it before the Honorable Supreme Court. Honorable Supreme Court passed an order, granted an interim status quo as regards possession and construction.
Till when?
Till such time, the way application would not be disposed of, and there has been a direction for expeditious disposal of the way application.
So way is still pending.
No, way has been challenged before this period WP.
Now the way has been dismissed.
Yes.
So
kindly see.
You said there is urgency. Subsequent order is passed. This order was.
No, immediately that would be promulgated. Now, since the way application, my interim order was
revived.
Yes. Kindly have a look at page 102.
So now there is no status quo order.
No.
And there is the
original application has already been dismissed.
102 where Supreme Court order you are saying we are proceeding on. Let us see the present impinging judgment now.
Yes.
The final order. Just the relevant portion.
Page 119.
119. They have observed that, my lord, it is my obligation to prove the case.
Yes, we are of the considered opinion that applicants have failed to establish.
My lord, kindly see, my lord, page 121.
Yes.
Because prior to that, my lord, since there is an alternative remedy, I did not avail of an alternative remedy, but the Honorable Supreme Court directed to consider this on merit. They have considered it on merit.
Alternative remedy as in appeal against this?
Yes. But that revisional commissioner did not sit, my lord. Subsequently, approach. They 5 times, my lord, they did not take any action. Immediately thereafter, we approached. So that is not an issue over here.
He's in a embarrassing situation. We can understand, but if this is carried out, then it will be more embarrassing for the court.
My lord, kindly have a look at the third paragraph. The principal contention advanced on behalf of the applicant is that the authority below failed to conduct an inquiry in the manner contemplated under Rule 166 of the manual, and that undue emphasis was placed on the authenticity of the property tax receipt instead of the deciding the issue on the basis of the material available on record. It has further been urged that the Panchayat certificate having not been specifically disproved by the issuing authority, the collector ought to have been accepted the same as sufficient proof of the existence of the structure prior to 24th of March 1986. Reliance has also been placed upon the such a judicial decision to contend that official act to carry a presumption of regularity, and that the tribunal is competent to entertain the application notwithstanding the availability of the alternative remedy. The learned government representative on the other hand has supported the impugned order, contending that the collector afforded the adequate opportunity to the applicant.
Yes, Mr. Dattu, we are granting interim order, interim protection for a limited period. Let Mr. Bhattacharya come.
My lord.
My lord,
when should you keep it?
Can the order passed on Monday, my lord, in presence of Mr. Bhattacharya?
Till Monday, if his hotel is demolished, then what happens? We'll keep the matter on Monday, but we'll grant interim protection for a limited period. We take up the matter under peculiar circumstances. First up, in the morning, the learned senior counsel, senior standing counsel Mr. Bhattacharya, appearing on behalf of the state, had sought an adjournment on his personal ground. First up, we were given to understand that information regarding such adjournment had been duly given to the learned advocate for the petitioner. First up, next para, however, when the matter was not called on serially, Mr. Dotto, learned counsel appearing for the writ petitioners proceeds forward and submits that no consent was given at any point of time, any point of time regarding any concession for adjournment. Full stop. What was intimated to his learned advocate on record was that the matter would be mentioned seeking adjournment, for seeking adjournment. Full stop. Next para. That apart, Mr. Dotto apprises us that the matter is extremely urgent, since the writ petitioners run the risk of their structure being demolished pursuant to the orders passed by the Block Land and Land Reforms Officer, Namkhana, South 24 Parganas, which was assailed before the West Bengal Land Reforms and Tenancy Tribunal in an original application, against the dismissal of which the present writ petition has been preferred. First up, in the teeth of such extreme urgency, we have no other option but to consider the matter for the purpose of for the purpose of assessing whether limited interim protection ought to be granted. Push up next para. The concerned Block Land and Land Reforms Officer, by the order dated December 26, 2023, which was assailed before the tribunal, had observed that after perusal of the documents produced by the writ petitioners, in the context of their post facto plea of conversion, felt that it was highly required to verify the authenticity of the said documents. Pushed up. However, it was observed that verifying all the way round, double inverted mode, verifying all the way round it purota, the authenticity of the receipt could not have sustained as it is not supported by any cogent evidence, either implicitly or explicitly, within bracket whatever that meant, bracket closed. Full stop. Next para. On such consideration, the application for conversion was rejected. Full stop. Next para. As a consequence of the said order, on January 30, 2024, the Block Land and Land Reforms Officer directed implementation of the same, further directed implementation of the same. Full stop. Next para. Learned counsel for the petitioners brings to the notice of the court Rule 166 of the West Bengal Land and Land Reforms Manual, 1991, under which the matter was being considered by the BL and LRO. Full stop. As per the said provision, it is submitted, it is the duty of the collector, while disposing of a petition for conversion, to undertake an inquiry on the criteria as laid down in the said provision. Full stop. As per clause small I within bracket of Rule 166, it should be inquired as to whether the change in use, if any, had been made in the usual course of nature or by deliberate action on the part of the applicant or by any person, semicolon, and in the latter case, it should also be ascertained whether the change took place before March 24, 1986, that is the date of publication in the official gazette of the West Bengal Land Reforms within bracket Amendment, bracket closed, Act, 1981. Push up next para again, in clause Roman II bracket of Rule 166, it is stipulated that if the change in the use of land has occurred within bracket small a in the usual course of nature, or small b bracket has occurred at a time when such change was not unlawful within bracket vide proviso to section 4 capital B bracket closed, or small c within bracket has occurred due to developmental activities of the government or of a local body in the surrounding area, or small d within bracket due to urbanization in the surrounding area, comma, the applicant should be informed that the change is being noted in the records of rights and the said records should be corrected accordingly in due course. Full stop. Next para, it transpires prima facie that both the tribunal and the block land and land reforms officer failed to take into consideration the uh, legal connotation of the provisions of Rule 166 and the requirement thereunder and the obligation cast thereunder on the collector himself to undertake the inquiry as indicated in the provision. Full stop. Next para, instead, comma, in a cryptic fashion, comma, the application for conversion filed by the writ petitioners was rejected by entirely putting the onus on the writ petitioners to establish their case. Full stop. Next para, in view of the nature of the proceeding under section Rule 166 of the 1991 manual being inquisitorial as opposed to adversarial, comma, the writ petitioners have made out a prima facie case for the hearing of the present writ petition. Full stop. Accordingly, there shall be stay of operation of order number 3 dated December 26, 2023, passed by the additional district magistrate and district land and land reforms officer, comma, South 24 Parganas in
way number.
no, in case number 59 within bracket C stroke 351 stroke P stroke 23. Stay of that would not help you. Stay of the way would, as well as stay of operation of order number 4 dated January 30, 2024, passed by the block land and land reforms officer, comma, Namkhana, comma, district South 24 Parganas in miscellaneous case number 360 stroke 23 within bracket district South 24 Parganas bracket closed till August 15 to August 14, 2026, or until further order, comma, whichever is earlier. Full stop. The matter shall be listed under the appropriate heading on August 3, 2026. The matter shall be listed under the heading specially fixed matter on August 3 na kore to August 5 kore. August 5, 2026. 5th August, specially fixed matters, so that Mr. Bhattacharya also has a chance to oppose and whatever. Thank you.
I'm really sorry for the
inconvenience.
No, you are not at fault at all.
These are the affidavit of service, Milord.
Affidavit of service felt to be kept on. Maybe Mr. Bhattacharya is not like that. There must have been some misunderstanding, but we cannot overlook because we have to see through all of you and look at the litigant, who he is representing. Thank you.
Grateful.
Thank you. হ্যাঁ হ্যাঁ